नितेश भाई, अभी प्रोग्राम बात डिस्कस हो रही थी शशांक जी से कि मेरे सेशन के बाद क्वेश्चन आंसर सेशन होने के बाद आई विल लीव द मीटिंग.
Good morning, everyone. Good morning, everyone. I welcome you to this refresher course on direct tax. Friends, today we have two reasons to cheer up. We have two leaders from two different regions. CA Shashank Agrawal, Chairman EIRC, and none other than CA Devendra Somani, Chairman CIRC, are also with us. Friends, there is one more reasons to cheers for the EIRC members. Today, both the chairmen, seeing the structure of our refresher courses, they had agreed that these will be live cast on their YouTube channels also. So the members of CIRC and NIRC can also get the benefits. So it is a proud moment for all the three regions. The three regions have come together today so that the profession at large, the members at large can get the benefits. So with this, may I request CA Somani ji to kindly address the members.
Good morning, everyone. Thank you, Nitesh bhai. CA Ashwini Taneja, advocate, and CA Shashank Agarwal ji, Chairman, Northern India Regional Council, and my friend CA Mahesh Bajoria ji, and Amit Khemka sir, and all the viewers of three region, Eastern and Northern and Central India Regional region. I think we have created a new history. A few days back, we organized one all region joint webinar. And the feedback was that excellent, and it was idea of Mr. Shashank and Mr. DC Jain and Nitesh ji. And I know Nitesh ji since so many years, and he is excellent in technology and social networking. And we all are using that social networking and in this COVID-19 era. So we all have, it is a great epidemic, but we have to take use of it. And Nitesh ji, under EIRC, under the leadership of Nitesh ji, is doing excellent. Every day when I am seeing that he is organizing such memorable events, so I requested him that Nitesh ji, this we will also telecast in our region, because everyone will be benefited from that. No, I am not taking much more of your time, and we will definitely members of all the regions will benefited from this today's event. So now I hand over to Nitesh ji. Thank you once again for inviting me in this event and giving an opportunity to of Central India region channel to live webcast this program. Thank you very much. Thank you,
sir. Very thank you for this initiative that we all are together. The large objective is to serve the members and students, and we together can achieve this. Thank you. I would request Chairman NIRC, please.
Jai Shri Krishna. And again, as Devendra ji said, I also say in a very few words that Nitesh ji, your efforts are very great for all the fraternity. And as we all are working together, so, and as we have the faculties from Delhi and all the NIRC, when I see your course, so I really felt obliged ki, sir, we also want same course in our NIRC with you only, because
yes.
It's tricky to manage and broadcast the same knowledge across the regions. So I believe three regions are working at this moment together for sharing the greatest knowledge of Ashwini ji, Amit ji, and Rakesh ji. All the panelists we have decided. So it's a great field to be working with all the regional chairmen together. Again, thank you Ashwini ji, Amit ji, for giving your assent. And yes, we are live on the three platforms together for the larger benefit. again, Niteshji, thank you so much for giving this opportunity. Thank you, Ashwini-ji. Thank you.
Thank you so much. We all regions are together and we will achieve the larger objective, that is to serve the members and students, and for which we will work together and we'll see how best we can do for the members and students. Thank you to both of you. May I now request, I think the Badhani ji, and he has not come. I would request Manish Goyal, who is supporting us very well, to kindly introduce the learned speakers today.
Hello, good morning all. I would like to introduce Mr. C.A. Ashwini Taneja, sir, and he needs no formal introduction. Yet, for the benefit of members, I am reading his profile. Sir Ashwini Taneja is a former member of Income Tax Appellate Tribunal. He is a fellow member of Indian Council of Arbitration, New Delhi. He is also a fellow member of the Institute of Chartered Accountants of India. He is also a member of the Institute of Company Secretaries of India. He is also a member of the Institute of Cost and Works Accountants of India and has done masters in law. He practiced as chartered accountant from 1995 to 2007 in varied areas of auditing, due diligence, tax planning and litigation, and business advisory and restructuring. Between 2007 to 2015, practiced as lawyer with the firm Messrs. RRA Tax India, New Delhi, appearing before ITAT, High Court and Supreme Court. In 2015, he was elevated as member of the tribunal and was posted at Mumbai bench, where he delivered more than 2,000 judgments covering wide variety of issues. Then in 2017, he resigned as member tribunal and joined back its odd chairman and passion legal profession. Currently practicing again as lawyer with Messrs. RRA Tax India, specializing in the area of anti-money laundering law, Benami Law, Black Money Act, SFIO, and Income Tax Act, and making representation before adjudicating authority under the Appellate Tribunal of Benami Law and PMLA, ITAT, High Court, and Honorable Supreme Court of India. He is a prolific speaker and was delivered presentation and lecture on different forums across the country regarding various issues of PMLA, Benami law, and income tax law. He is always available for discussion on issues arising on these subjects. Now I would like to introduce Mr. Amit Khemka ji. Mr. Amit Khemka is a litigation lawyer with experience of almost 34 years at the bar. He has handled large number of cases involving complex issues in the domains of criminal, civil, and constitutional law. Cases handled by him have made significant impact legally and socially. He has a large client list including corporate, professional, public servant, and politicians. For his legal acumen, he is regularly invited to All India Radio and various TV channels and has participated in about 400 debates on All India Radio and about 1,000 debates on TV and diverse legal subjects. He is addressing the Standing Committee of Parliament and regularly delivers lectures at different forums including chartered accountants, lawyers, doctors, and students. Now I hand over the section to Ashwini Taneja, sir. Hello.
Yes. Good morning to all my professional brothers and sisters, and very good morning to all my colleagues on the dais, all my respected, what should I say, epitome of our profession, Nitesh Moore, Chairman EIRC, my dear younger brother Shashank Agarwal, Chairman Mr. Nitesh Moore EIRC, and Mr. Shashank Agarwal, Chairman NIRC, and Chairman Saab of CIRC. I can't see him on the video. So this is a great opportunity to bring all of you together here and to share my thoughts to all of you. And special thanks to my esteemed colleague Shri Amit Khemka, who is of course not only an ace lawyer but a wonderful speaker. And we will get the benefit of his presence today when he will discuss about nitty-gritties of the prosecution aspects of these laws, which our chartered accountants are entirely understand before the matter slips in the hands of the advocates, and sometimes the issues are not properly handled for want of proper advice from the main consultant, who is mostly chartered accountant of a client. So therefore, I think very uniquely this program has been designed by EIRC, by NIRC, and by CIRC together, and which is being, I'm told, shared live. Especially at these moments when these are tough moments we all are passing through. So मैं अक्सर ये बात कहता हूँ कि एक चैलेंज है इस टाइम इन टफ मोमेंट्स को एक अपॉर्चुनिटी मोमेंट में क्रिएट करने का, कि हमारे पास ये टाइम आया है अपने आप को एक पर्सनल ग्रोथ देने का, एंड दैट इज पॉसिबल स्पेशली थ्रू लर्निंग, एंड इंस्टीट्यूट इज डूइंग दिस ह्यूमन सर्विस बाय ऑर्गेनाइजिंग दिस प्लेटफॉर्म सो दैट जो लर्निंग चैनल है हमारा वो ऑन रहे. तो आज मैं सुबह ऐसे ही बात कर रहा था घर में, तो मैं एक चीज बोल रहा था कि ये दो बहुत बड़े हमारे सामने टारगेट हैं जो लॉकडाउन में, स्पेशली लॉकडाउन में हमारे को पूरे करने होते हैं. और वो टारगेट, टू बी ऑन द लाइटर साइड, इज वन इज दिस, कि हमारे को जो स्लीप है वो ऑप्टिमम आए, यानी कि ना ज्यादा ना कम, जितनी होनी चाहिए स्लीप उतनी आए. और दूसरा, मेरा जो डाइजेशन है वो इतना अच्छा रहे कि मुझे 3 मिनट से ज्यादा ना लगे अपना पूरा स्टमक क्लियर करने में. तो अगर ये दो, ये भी लाफ एट इट, बट अगर ये दो टारगेट आपके पूरे हो रहे हैं तो इसका मतलब आप अपने जीवन का व्यतीत बहुत अच्छे से कर रहे हैं. और उसके लिए जरूरी है कि आप अपने आप को अच्छे से अलाइन करें, और अच्छे से अलाइन करने के लिए लर्निंग, कांस्टेंट लर्निंग जरूरी है. कांस्टेंट लर्निंग जब होती है तो नेचर ने कुछ इस तरह से हमारी बॉडी को डिजाइन किया है कि लर्निंग जब तक होती रहती है हमारी अलाइनमेंट बनी रहती है. द मोमेंट लर्निंग स्टॉप, तब सारे विकार और सारी प्रॉब्लम, सारे वाइसेस, देन दे टेक बर्थ. So we should be really thankful to the institute that in any manner, one way or the other, we are getting opportunities to learn, and we are being made to learn every day new things. So thank you very much, and thank you, my brothers and sisters, for sparing your valuable time and your participation with which we'll make this session wonderful, and especially the session on Benami law, and the subject which is very close to my heart. So the first thing which comes to our mind, what is this Benami? Though many questions are arising under this law, like the first question which arises is whether this law is going to be retrospectively applied upon us, whether the all past transactions will be invoked, all they can be also roped in, whether there is going to be a scope of any mens rea, meaning thereby if a person has done by mistake a Benami transaction, still he will be hit by the rigors of this transaction. Then can everybody else please switch off the mic, because various sound I can feel. So I will request everybody else to switch off the mic so that other sounds are not disturbing the audience. So whether there is any threshold limit, कि भाई इस लिमिट से ऊपर की प्रॉपर्टीज को रोप इन करेंगे, इससे नीचे की प्रॉपर्टीज को रोप इन नहीं करेंगे. Whether there is any scope of what should I say, any U-turn, कि suppose I have done Benami transaction by mistake, I want to correct this, तो क्या कोई compounding का, कोई U-turn का कोई scope है? Whether if tax has been paid on this, if tax has been paid on this, whether still a person can be, or for the same transaction, hit by Benami law also. Whether if by mistake I have purchased a property which is Benami property, in fact, whether I can get a protection, or this will be definitely confiscated, meaning thereby whether any protection to the bona fide purchaser, whether only immovable assets are involved or movable assets are also involved, whether it applies to only public servant, politicians, or it applies to private citizens also. It is applicable to business entities also, like listed companies also, whether it applies to urban people or rural people also. So there are many more such questions which are arising in our mind. And believe me, most of the answers you will get will be reverse of what we will be thinking on the basis of our common sense. So, friends, this is a very strangely drafted law. Believe me, I do not feel any hesitation in saying so, and for various reasons. The first question is with regard to retrospectivity, because if this law is retrospectively applied, then believe me, disaster is waiting for many people. There will be a lot of hue and cry, because unknowingly some transactions have been done, and there does not seem to be any scope to make any distinction if by mistake transaction has been done or transaction has been done knowingly. So before coming to that, because we are interested in knowing the retrospectivity part, it is very essential for us to know what is Benami, where from this word cropped up actually. Whether this word Benami is of Hindi, Sanskrit, which language. In fact, Benami is of Persian language. That means the word Benami came up in our consideration, in vogue in our consideration when Benami transactions, when Persian rule was there, because this word is from the language of Persia. So that means when Persian language was vogue in our country, when Muslim rule was there vogue in our country. So that means Benami transactions were happening even at that time. So I am taking you to the evolutionary background so that we can understand the concept of retrospectivity also, that how and from which date this law can be applied. So that means when Muslim rule was applicable in our country, if Benami transactions were happening in our country at that time, that means the origin and the history is too old. And not only that, I will show you and I will share with you one important information, that even in British era, not only Benami transactions were happening, but British government allowed Benami transactions to happen. Through express legislation, this permission was given. You may not probably agree with me unless I show you the law which was made at that time. I will share my screen. I will share my screen. So kindly bear with me for a second. Screen is visible. Can you see the screen? Yes. Yes. So friends, as I was talking to you, that even at the British period, Benami transactions were happening. Not only Benami transactions were happening, rather I would say British government allowed Benami transactions to take place, because it was observed that British government did not normally disturb all those customary practices which did not disturb their strategic movements. So therefore, this was a customary practice indeed to do Benami transactions in the country, and that is why it was allowed by the British government, which will be evident from this Indian Trust Act, which was enacted in 1882. So you can see Section 82. I will read before you Section 82, which says, where property is transferred to one person for a consideration paid or provided by another person, and it appears that such person did not intend to pay or provide such consideration for the benefit of the transferee, the transferee must hold the property for the benefit of the person paying or providing the consideration. Similarly, Section 81, it also read something on the similar lines. I'll be sharing this PPT, so you need not note it down. Then kindly read Section 94. It also says something similar. In any of the case not coming within the scope of any of the preceding sections, where there is no trust, but the person having possession of the property has not the whole beneficial interest therein, he must hold the property for the benefit of the persons having such interest, or the residue thereof, to the extent necessary to satisfy their just demands. So these three sections, friends, said only one thing, that in case a person wanted to transfer the property to another person, but without having intention of transferring the full beneficial or ownership rights therein, then the law protects such intention of the transferor, and such ownership and beneficial rights are not transferred in absolute. So meaning thereby, it was allowed to do transaction in other names, but still retaining the full control of the property. Meaning thereby, in simple words, Benami transaction could have been done at that time, as per the express legislation. Similarly, kindly see Section 60C of Civil Procedure Code, which was enacted in 1908. Similarly, kindly see our own Indian Income Tax Act also allowed Benami transactions. That to 1961 Act, not 1922 Act, because its Section 281A prescribed that this Benami transaction can be done subject to furnishing of information to the jurisdictional commissioner or chief commissioner. In other words, a person could have done Benami transactions subject to maintaining the transparency to the extent of giving information of Benami transactions to the jurisdictional commissioner or chief commissioner. Meaning thereby, in case a person gives proper information, then he could have done Benami transactions. This was very much allowed by the Income Tax Act itself. And in case the person does not give the information, then no punishment was prescribed, no acquisition of asset, no other consequence, except one, that the person who was owning the property really would be deprived of his right to claim the property by way of legal suit. So only his right to file the legal suit would have come to an end. That's all. Nothing more, nothing less. So in other words, doing of Benami transaction was allowed, subject to maintaining the transparency of giving information to the commissioner or chief commissioner of the jurisdiction. Now then, what happened to all this law which I have just put before you? In fact, its origin lies back to 1969, when for the first time in the country, Taxation Law Amendment Committee gave assignment to the Law Commission that various reports have been received which are suggesting that many Benami transactions are happening in the country which are creating trouble in the economy. So what should be done about these transactions? This was the assignment which was given to the Law Commission, and to also find out whether transactions are happening. If yes, what should be done? Whether they should be regulated, prohibited, or nothing should be done, etc. Then Law Commission at that time took around 5 years, and in 1974, for the first time, Law Commission came back with its report on Benami transactions, and it was opined therein that yes, Benami transactions are happening, and the first cause of happening of doing of Benami transaction was not tax evasion, but first cause was the first reason was violation of certain civil laws, and the second reason was, of course, tax evasion. Civil laws means the laws which were brought out post-independence by various states in the country to eradicate feudal system, like Urban Land Ceiling Act, like UP Land Reforms Act, like Maharashtra Land Reforms Act. And for every state, probably this kind of law was brought out so that even distribution of land can be made, whereby the land from the hands of few landowners, landlords, it could be redistributed to the masses comprising of landless people, landless laborers. So these laws were being violated by buying the land in other names. So that is why it was prescribed. Yes, there are many reasons due to which this law should be regulated, and these transactions should be regulated or even prohibited. So such kind of detailed report was furnished. But nothing was done till, I think, 14 years, from 1974 to 1988, when for the first time ordinance was brought out, that is Benami law, in the name of Benami Transaction Ordinance, Benami Transactions Prohibition Ordinance 1988, which was brought out in 19th May 1988, and it became an act as if there was some emergency-like situation, because it was brought by ordinance, and it became an act in very short period on 5th September 1988, when it got the assent of the president. So it was notified as an act. And the main thing was, all this law which I had discussed before you, all these sections was repealed, meaning thereby section 81, 82, and 94 of Indian Trust Act and this section 281 of Income Tax Act, they were repealed, meaning thereby the endorsement from the legislature to allow the doing of Benami transaction was stopped. And the law was brought out in very crisp, in very prohibitory form, in very crisp manner. Only 9 sections were there at that time. Since we want to understand the retrospectivity part, it is therefore I find it is essential that we must understand also the part related to how the law was brought out and whether the law was in active mode. If it was active mode, then why we were not aware about this law, why it was not properly implemented. If implemented, then why we were not aware of, and why there was a sudden jerk upon us when the law was substantially amended in 2016. So some of the sections I'll be reading to connect the old law with the new law. So firstly, section 1.3 talks about, I'm talking about the old law, talks about the commencement of the act. So as every act has a commencement section, this act has also a commencement section, with the distinction that in this case, commencement is bifurcated into 2 parts. So I mean, the 3 sections commence at once, and other sections commence from 19th May 1988. And that makes the whole lot of difference while we will study the retrospectivity part in the current legislation. The provisions of section 3, 5, and 8 shall come into force at once. Now, at once means the day when the law is legislated, meaning thereby when the law is notified, and it is notified from 5th September 1988. So section 3, 5, and 8 of original law came into force on 5th September 1988, and the remaining provisions, meaning thereby 9 sections minus these 3 sections, remaining 6 sections came into effect, deemed to have come into force on 19th May 1988. Kindly do remember this section. It's very strangely worded section, and we will be needing it again while we will deliberate on the current law. Section 2A is the definition clause, and section 2A says Benami transaction means any transaction in which property is transferred to one person for a consideration paid or provided by another person. So this definition is very, very short definition. But short does not necessarily mean sweet when we talk about prohibitory law, because it is very sweeping, and it sometimes it tends to cover even unintended situations. Like, I will give you a small example. If a person made borrowing from the bank to buy a property, and if the bank disbursed the loan directly to the seller of the property, then literally speaking, if we apply this application in literal sense, then that situation can also be called as benami transaction, because the consideration was paid by banker, and it was transferred to another person, because something was missing in the section, which will be further evident when we will read the current section. It will establish that this section was incomplete. Anyways, let's proceed further. Then section 3 read as, no person shall enter into benami transaction. And then there was, so it is very clear, the legislation is very clear. It is saying no person shall enter into benami transaction, meaning thereby they are clearly saying that no, there is no ifs and buts. Even at that time, the law was very clear. No ifs and buts means no scope of any mens rea, any reasoning, any classification. No means no. It will not be done at all for any reason whatsoever. The only exception was that if the property is purchased in the name of wife or unmarried daughter by a person. So no relief even to poor husband. And what to say of son, and that to only unmarried daughter, as if the daughter will not be daughter once she is married. And except that, no other exception at all. So such a sweeping law, I would say draconian law, even at that time. There must have been reasons behind this, definitely. Then section 3, subsection 3 read, whosoever enters into benami transaction shall be punishable with imprisonment for a term which may extend to 3 years, or fine, or with both. So punishment was also there of fine and imprisonment of 3 years. And then it was also prescribed that the offense shall be known cognizable. And what is non-cognizable, what is bailable, what is non-bailable? I will request our Amit Khemka ji to kindly deliberate on these issues when we will be discussing about the prosecution aspects. Friends, I have found that we chartered accountants, though we have very good understanding of the issues, but while we talk about prosecution, then we fall short of understanding the basic concepts. And that is why, even if the prosecution is mainly handled by our advocate brothers, but since lack of support from the chartered accountants, certain various issues are thrashed or represented on ad hoc basis, which is neither good for the chartered accountant, nor for his client, nor for that advocate brother. So it is essential that chartered accountant should also perform their role. So I would request Amit Khemka ji to cover the prosecution aspects in a manner that we chartered accountants can understand it properly. Then section 5 says, all properties held benami shall be subject to acquisition by such authority in such manner and after following such procedure as may be prescribed. So if law was there, punishment was there, definition was there, then what happened to this law? It is because of section 5, because entire buck stopped here. That is on section 5, because no such authority was ever prescribed for acquisition of the property. No enforcement agencies were ever created. No grievance redressal mechanism was created. No appellate mechanism was created. So you can say that this law remained more or less like a paper tiger. So in other words, प्राण रहित शेर, जिसको I can say आपके दरवाजे के ऊपर बिठा दिया, and when you came out of your doors in 2016, the life was infused in that tiger, and that is how the new amended act was introduced before you. Now, amendment was brought out in 2016, as we all of us are aware of. Before the amendment, the matter was referred to the Standing Committee on Finance under the chairmanship of Shri Virappa Moily, and to discuss about, to consult, to guide us about the nitty-gritties of this law. So before this government, present government came into power, before that, this bill was already introduced, and therefore the justification or the reasoning or the analysis was required on the bill. So Virappa Moily Sahab gave his report comprising of more than 200 pages after consulting various people from the country, from located all over various corners of the country, wherein it was opined that this law, if it is presented in this form itself, then it will prove to be very harsh and draconian, and there may be a lot of hue and cry, and more than 50% of India can be declared, whether rural or urban, can be declared as benami. But despite that, without making any substantial amendments, this law was introduced as per the wisdom of our honorable government, and that is how this amendment was made. So the amendment was made in this manner that no new law was not introduced, earlier law was not repealed, and amendment was made by the Amendment Act of 2016. Now you might say ki, why not earlier law was repealed? Because there are around 74 sections, and in earlier law there were only 9 sections, so it was like inserting large ship into small boat. So this very question was asked from the honorable finance minister, late Shri Arun Jaitley. At that time he was our honorable finance minister, and when it was asked, so he was very witty in giving reply, and he said, yes, there seems to be sound reasoning what you are saying, but the government has its own sound reasoning. And the reasoning was that the government did not have the government did not want to give immunity to the people who have done Benami transaction in last 28 years. 28 means 2016 minus 1988. So therefore, since the immunity was not to be given to the people, therefore earlier law was not repealed and only amendment was brought out. In other words, as if he was giving the intention of the government that it is the law which is applicable from retrospective date. But whatever the case may be, whatever the opinion of the honorable finance minister may be, but that would not be conclusive in comparison to the law. If the law say whatever the law says, I think the courts will hold that as the conclusive portion. Of course, some support can be taken wherever vagueness will be there from the speech given at the floor of the House in the Parliament. But now let us read the law as it is. So amendment was brought out in the same fashion, probably as is done in Income Tax Act, that Amendment Act contains new sections, the amendments in the old sections, and these two things are infused in the existing act, and or earlier unamended sections remain as it is. So similar thing happened here. So section 1.3 remained as it is, no amendment, no nothing new was done. So I will read section 1.3 as it is because this is a commencement section. It will decide the retrospectivity primarily. Provisions of section 3, 5 and 8 shall come into force at once. Now at once means what, brothers here? Now at once means in the context of the earlier section, it meant 5th September 1988. But now, today also, it will mean the same thing. Yes, one opinion of the House will be yes, it will mean the same thing, 5th September 1988. But substantial amendments have been made. 3, 5 and 8 have been changed. Rather, section 8 is totally changed. So what will be your opinion in such circumstances, friends? I know the House will be divided as far as this opinion is concerned, because wherever I have given deliberations, even before commencement of the webinar system since lockdown, when we used to meet physically person to person, and when there used to be better interconnect, I would say, better, we have got the facility of internet. At that time, we used to have the facility of interconnect. So during those periods, moments of interconnection, very good opinion I had the privilege to get from the various learned esteemed members from the audience, and but the opinion was always divided, and many people said no, it will be still read from 5th September 1988, and somebody say no, since these have been substantially changed, it will be read from 1/11/2016 when this new act has been introduced since then. But hold on, friends, the controversy will become more large when we will read the remaining half of this act, of this section. And remaining half reads like that: and the remaining provisions of this act shall be deemed to have come into force on the 19th May 1988. Now, remaining provisions means what? Remaining means 9 sections originally drafted minus these 3 sections, or now remaining means, because we are reading it in the present act has 74 sections, so 74 minus 3, that is 71 sections. So remaining means what? So friends, again, the controversy is so large, and definitely the opinion is going to be divided in 2 or 3 or 4 parts, or I do not know how it will have to be interpreted. So because it is producing absurd results in whatever way we may opine, it is going to produce very disharmonious results. So therefore, when we argue it vociferously as a seasoned lawyer before any court of law, let us be, for the time being, optimistic that the court may be impressed. The court may say, okay, Mr. Taneja, let us take section 1.3 as otiose qua new law, redundant qua new law. We will read section 1.3 qua old law only. So meaning thereby section 1.3 may not decide retrospectively. Let us presume for a moment. Even if presuming it's so, let us find out whether still there is anything under the law which makes this law still retrospective. That is the other question which we must answer, and that is what I am going to discuss with you in my next slides. Friends, this law has been drafted fantastically. I would say very comprehensively this law has been drafted. Earlier, whenever the law was drafted, there would be some loopholes. People will make misuse of it. Then it will be punctured or repaired. Then again, punctured or repaired law. Again, there will be some loopholes or misusage. Again, it will be punctured. So this time, some in-house drill was done indeed. And the law was drafted in this fashion that 10 visualizations were done. Okay, if it will be punctured or in this manner, then how it will be repaired. And again, it will be punctured, how it will be repaired. And probably at the 11th time, whatever the output was there, that has been presented by way of the new legislation, which will be evident from this fact that the definition itself of the under the new law, under section 29, contains 4 parts: part A, B, C, and D, and which covers the all possible life situation you may envisage. I will discuss with you. And friends, the beginning of the part A itself is quite sweeping. It starts with the words a transaction or an arrangement. So somebody may say, no, I have not done any transaction. Then immediately the reply will come from the legislation that, oh, okay, you have not done, may not have done any transaction, but you have made an arrangement. Okay, so you can't escape. Please read further. So a transaction or arrangement, then condition number A is where a property is transferred to. Now kindly see, friends, how many commas are there. I will read for you. How many commas are there? Where a property is transferred to, comma, or is held by, comma, a person, comma, and the consideration for such property has been provided, comma, or paid by, comma, another person, comma. So I read this news somewhere in Times of India that somebody in USA had to pay heavy fine for improper or no use of comma where it was required. So they thought, why to be miser on comma? Have comma after comma. So I will show you that there is a magic of this comma only. I will read it with you. Where a property is transferred to, this is a separate compartment because it succeeds with comma. It ends with comma. So where a property is transferred to, meaning thereby this is one compartment, another compartment starts. So as I said a few minutes back, that let us be optimistic about the fact that the section 1.3 will not come as a hindrance, and the court may say will not read it here. So if it is so, then the date of transfer should be what? Then the date of transfer should be, of course, post 1/11/2016, because it has to be counted from that date. Its enforcement will be from 1/11/2016. So date of transfer should be from that date or after that. Only then this clause will be applicable. All right, admitted. Let's move further. Or is held by. So held of the holding of the property should be when? Of course, post 1/11/2016, on the day whenever the notice is intended to be issued by the enforcement agency. So, all right. So holding should be on that date. But held since when? Yes, hold on. Here comes the big question. Held since when? So again, there will be many opinions. Somebody would say held since 2016, but there is nothing is mentioned as such, because they are saying if held as on date. Somebody would say, sir, held since 1988, because the original law came since 1988. And somebody would say, no, sir, since there is no embargo put, so held since any time, maybe time immemorial. So friends, there you are absolutely right. So the courts may at the most, if they are very passionate or very compassionate, they may say, okay, let's take it from 1988. But it has to be taken whenever the property was held since when. So that is what, that it tends to make this law as retrospective. So earlier transaction, the legislature will try to rope in this manner because of this word held. So it has been made kind of continuing offense. Friends, as far as judicial background is concerned, there are 3 judgments which we have in the country so far. First judgment came from Honorable Rajasthan High Court in the name of Niharika Jain, which said that this law is not retrospective. But with due respect to the judgment, neither section 1.3 was interpreted nor the word held was interpreted therein. Then another judgment came from Honorable Justice Koshi, from Chhattisgarh High Court, wherein it was opined that yes, this is retrospective, though proper reasoning with regard to held was not there, but still all the definitions were taken and it was said it will have retrospective effect. Then we came the third judgment from your own jurisdiction, that is Honorable Kolkata High Court, in the name of Ganesh Dealcom, in which it was opined, yes, it is not retrospective, so Niharika Jain was followed. But again with due respect, word held and Section 13 was not interpreted properly. I mean, with due respect. So that was my reading suggested. I may be wrong, if you can read it again. So then, therefore, friends, the Income Tax Department took the matter before Honorable Supreme Court, and the matter is pending before Honorable Supreme Court. So therefore, we do not have right to express opinion as such. So we are just reading the law. Unless now Supreme Court, intervenes, I think there is not going to be clarity on this because of the way the law has been drafted. So leaving it at that stage. And yes, one important facet. So this is about the retrospective law. What about the prospectivity? Meaning thereby you will say, Kitane sab, okay, if I do the transaction today, I have done the transaction earlier, I may be roped in because of this word held, etc., or whatever you may say. But suppose I do the transaction today. In future, up to what extent I can be roped in? Meaning thereby that transaction can be roped in by the Benami law of officers, meaning thereby the BPU, law enforcement agency. Up to what time? Few months, 1 year, few years, 1 decade, 2 decade, my lifetime, or even after my lifetime, they can trouble my children. Okay, the property which your father Saab had left, this is not an asset, this is a liability, give it to us. So what is the time limit? Very important question, friends. In fact, when I was making analysis of this law, I was trying to find out the logics behind it. And to find the logics, I traveled back into the history to find out if they have derived logic from anywhere. And while I was traveling back, I traveled back up to 5,500 years when I got into my hands one beautiful piece of legislation. Yes, the legislation, as you all know, in the name of Srimad Bhagavad Gita, wherein you you may laugh at it, but maybe I am able to connect some of the logics given in that legislation with the logics for drafting the provisions in this manner. The first thing which was said by him, that समय अनंत है ना इसका प्रारंभ है ना अंत है. So timeless beauty. So the time is eternal. It has no beginning, no end. So that is how this Benami law has been made a timeless beauty, friends. So what to say of the past transactions? There is no time limit for the future transactions. So na bhoot na bhavishya, sabko merge kar diya. I don't know what is the logic beyond that, behind it. That I have not seen any such legislation so far, this kind of legislation particularly, which is so harsh that it is unfettered, which is boundaryless of any time, which has no time limit. So leaving it at that stage, let me read the definition clause completely. Where a property is transferred to or is held by a person and the consideration for such property has been provided or paid by another person. So again, it is succeeding with the word and. So and means the other transaction, other clause has to be read in conjunctive manner. So both the conditions have to be fulfilled. And other condition reads as, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. So this other condition is actually the most beneficial. It is the beneficial test. In fact, it is the litmus test. It is the most important aspect of the definition, because both the conditions have to be conjunctively read. If any one of the condition is not fulfilled, it will not be Benami. Somebody's mic has been put on mode. Probably kindly switch off the mic. Whosoever mic has been put by mistake on mode. So the property has been held for the immediate or future benefit. So to give you a small example, suppose I call my driver and I say, look, Mr. Driver, this is my car. You get it registered in your name now, and take it, enjoy it for your family, etc., etc. Whether it will be Benami? Of course, no, because the Benami test is not fulfilled. Mahesh Bajoria Saab, if you could kindly switch off your video and your mic both. I request you, please. So, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. So since it is not fulfilled, it may not be Benami. Now let me give a small change to the facts. Suppose in the second situation, I say, okay, Mr. Driver, you keep this car, get it registered in your name, but whenever I need for myself, my family, my friends, for whomsoever I say, you have to bring it. Benefit test complied? Yes, complied. So these are the simple facts to convey my thoughts. In this case, this can be treated as Benami if the facts are proved like that. So that is how the benefit test's mandatory requirement comes into play. Now, next part, B part. A transaction or arrangement in respect of a property carried out or made in a fictitious name. A transaction or an arrangement in respect of a property carried out or made in a fictitious name. So kindly see, friends, a transaction or an arrangement, again, sweeping words, and made out in a fictitious name. So word fictitious, for the first time, I am looking at in any legislation. So anything which is fictitious name, made in a fictitious name, will be straight away Benami. Nothing more is required to be proved. Now, fictitious names like somebody is keeping the property name in the name of deity, in the name of any goddess, in any name which is not recognized as a person in the eyes of law, maybe his pets, maybe something, some board, something, etc., which is not recognized as a person. So any such thing which is not recognized as a person, the law will straight away take it as Benami. And the consequence for the same would be, we will definitely discuss in few minutes from now, that what will be the consequences. Consequences are very severe if the moment a property is treated as Benami. Then C, a transaction or an arrangement. Again, transaction or an arrangement in respect of a property where the owner of the property is not aware of or denies the knowledge of such ownership. So friends, this used to be taken as lightly earlier, that a person used to say, okay, I am not aware about who has, done this transaction and how this property is in my name. I'm not aware of, I don't know about this and all that. So it was difficult to make any kind of addition or assessment for such properties. Now it has become very easy. If you have no knowledge about the ownership, etc., this is under clause C, straight away Benami. So wherever such takes place, if the lady of the house is not able to divulge ownership details of the shares, the partnership ratios, and the assets, then clause C may be applied. It will, of course, subject to the various provisions of Indian Evidence Act as are contained in section 91, 92, 101, 102, and 106 of Indian Evidence Act. But, friends, believe me, the problem will start. The whole burden will shift back upon you after this statement. Then clause D, a transaction or an arrangement in respect of a property where the person providing the consideration is not traceable or fictitious. So if you do not have the knowledge of the ownership, problem. If you are not able to tell who has paid the consideration, but you are having the asset, again there is a severe problem. If you are holding the property in fictitious name, again there is a problem. So unless the things are put in straightforward manner, there is going to be definitely a problem. So friends, that is why I say that now the time has come when we must realign ourselves. Now, realignment means realignment from the angle of being a person, a human being, firstly, then a citizen of this country, and then also as a professional. Now, realignment means we should know how to conduct my business, how to conduct my life. What is not to be done is very important to understand this realignment. In other words, I must know how to do the transaction at arm's length with my client, meaning thereby I need not be party to the transaction. I should learn to have the role of advisor only, and it should be confined to that, because when Amit Khemka will be discussing prosecution aspects under section 53, 54, and 54A, you will come to know that how huge responsibility is upon now auditors and chartered accountants who are advising. So friends, leaving it at that stage, there are only 5 exceptions to what I have mentioned by way of definition clause. So all those things which I mentioned in part A, part B, part C, part D are going to be Benami transaction, except if they fall in any of the 5 clauses. So if the 5 clauses में fall करते हैं, तो Benami से बचेंगे. Otherwise, there is no escape route from Benami. No ifs and buts, no concept of mens rea, etc. No reasoning, nothing. For this reason you can do Benami, for this reason you cannot do. No. If falling in definition clause, Benami, unless fall in these 5 clauses. We'll discuss that. So if property held by karta or member of HUF for his benefit or the benefit of other members in the family. 2. Property held by a person standing in the fiduciary capacity for the benefit of another person and includes trustee, executors, partners, directors of a person or a depository under the Depository Act 1996 and any other person as may be notified by the central government for this purpose. So friends, firstly that question which arises is फिड्यूशरी कैपेसिटी में सिर्फ वही इंक्लूड होगी जो यहाँ ट्रस्टी, एग्जीक्यूटर, पार्टनर्स, डायरेक्टर्स ऑफ ए कंपनी और डिपॉजिटरी लिखा है, या कोई और फिड्यूशरी कैपेसिटी में आ सकती है जो फिड्यूशरी कैपेसिटी इसमें डिफाइन नहीं है पर फिड्यूशरी कैपेसिटी है. सो फ्रेंड्स, आंसर टू दैट वुड बी यस, इट कैन कम प्रोवाइडेड दैट इज रिकॉग्नाइज्ड बाय द लॉ एज फिड्यूशरी कैपेसिटी और इन अ गिवन सेट ऑफ सर्कमस्टांसेस दैट इज रिकॉग्नाइज्ड एज अ फिड्यूशरी कैपेसिटी. सो फ्रेंड्स, any such thing can come in fiduciary capacity, and we can discuss little more about it little later if the time is left. Then I will give you one small example. Like for example, a holding company is supposed to hold 100% shares of wholly owned subsidiary company, but because of maintaining the number of shareholding, minimum number of shareholders, it is supposed to hold 99 shares and one share is held by its nominee on behalf of holding company. So this clause will save, because the nominee will be holding it in fiduciary capacity. So this clause will save him from being a benamidar. Otherwise, he would have been benamidar. The shares held so by him would have been benami property. Then third, property held in the name of spouse or in the name of any child. So friends, ये जो लॉ है ये बड़ी अजीब अजीब सी शिवरिंग दे रहा है, अजीब अजीब सी टेंशन दे रहा है. किसी को ऐसा लगता है कि ये मेरा बेनामी प्रॉपर्टी नहीं डिटेक्ट हो जाए, और किसी को ऐसा लगता है कि मेरा बेनामी रिश्ता नहीं डिटेक्ट हो जाए. तो जैसे जैसे क्वेश्चंस, जैसे जैसी टेंशन आती है वैसे वैसे भाव आते हैं और वैसा वैसा ही क्वेश्चन आता है. तो एक सज्जन ने ऑडियंस में से पूछा कि सर बेनामी प्रॉपर्टी इन द हेल्ड ऑफ स्पाउस तो ऑल राइट, बट द क्वेश्चन अराइजेस हु इज स्पाउस. सो I referred back the law and I said, look, this slide has been made very interesting for you. When we say benami property held in the name of spouse, the law says benami property held in the name of his or her spouse. So it is his or her spouse. And kindly don't be very excited. So immediately next question came कि sir any child का क्या मतलब है? So friends, any child means not all those things that you are thinking about. I mean child of any age, because we will see the definition which is given in Indian Succession Act and also Income Tax Act, and we do the combined reading in line with the reading of the subsequent clauses and in the context which has been read. Kindly see word lineal ascendant and descendant is given the subsequent clause. So therefore child of any age should come in this clause. So now we go to the next clause, clause 4, that is property held as a joint owner in the name of brother, sister, lineal ascendant or descendant. So friends, property held in the name of mother, suppose you buy property in the name of mother for emotional reasons, will be benami, of course, unless you buy the property as joint owner. So अगर आप मदर के नाम से या सिस्टर के नाम से प्रॉपर्टी लेते हैं, या फादर के नाम से या ब्रदर के नाम से, या अपने ग्रैंडसन या ग्रैंड डॉटर के नाम से, और आप अपने आप को ओनर दिखाते हैं कहीं कि आपने उनके नाम से लिया, आपने पेमेंट की, ऑनर अपने आप को दिखाया कहीं बैलेंस शीट में या कहीं, तो वो बेनामी होगी. अगर आप अपने आप को जॉइंट ओनर दिखा देते हैं तो ही सेविंग क्लॉज है. इसमें एक कंडीशन का हमें और ध्यान रखना पड़ेगा कि द पर्सन हु इज पेइंग द कंसिडरेशन शुड पे इट फ्रॉम द नोन सोर्सेज, KNOWN. This word has been used again for the first time I am seeing, otherwise in contrast to the words like declared sources or like disclosed sources, यहाँ पर words use है known sources. So known का मतलब I would say something which can be described and which may or may not be tax paid for the purposes of this act, but which can be described by the person who is paying. कि मैंने इस चेक, मेरे पास यहाँ से पैसे आए और मैंने चेक से इतने पैसे इस अकाउंट से दिए, एटसेट्रा एटसेट्रा. तो कैश में है तो कैश में कैसे दिए, एटसेट्रा. So that should be known, can be described, and I mean in times to come the courts will make further interpretation with regard to that. So friends, this is with regard to the property held as a joint owner and known sources की कंडीशन चाहिए. अब इन सब के पीछे आप सोच होंगे कि ये क्या बात हुई कि हम मदर के नाम से प्रॉपर्टी ले रहे हैं तो उसको क्यों बेनामी बना रहे हैं. साहब देखिए, लॉजिक इन सब का वही मिलता है वापस कि आपके अंदर पूर्ण समर्पण की भावना होनी चाहिए ना। पूर्ण समर्पण मीन्स अगर आप मदर के नाम से प्रॉपर्टी ले रहे हैं तो दैट मीन्स आप गिफ्ट देना चाह रहे हैं, तो गिफ्ट दे दीजिए ना। फिर आप अपने आप को क्यों ऑनर दिखाते हैं? गिफ्ट में कोई प्रॉब्लम नहीं है, आप मदर के नाम से लीजिए, उनको गिफ्ट दीजिए, गिफ्ट डीड बनाइए, पर आप अपने आप को ऑनर नहीं दिखाएंगे। ऐसा नहीं हो सकता कि मदर के नाम से चले प्रॉपर्टी पर ऑनर आप हो। नो दिस काइंड ऑफ ड्युअलिटी विल एग्जिस्ट नाउ। So friends, next clause is very important. Possession of any property taken or retained in part performance of a contract referred to in section 53A of Transfer Property Act. So this is meant to protect power of attorney cases, but with two conditions: that contract of power of attorney should be registered and the stamp duty applicable thereon should have been paid. Friends, now hardly in any situation this kind of conditions are fulfilled. So this is, I mean, power of attorney cases are really prone to attraction of Benami law, and I sincerely request the government to make out suitable amendments here, and at least for genuine cases. So friends, this was all about the exclusions, and except these exclusions, there is no exclusion. If anything falls in part A, B, C, or D, it will be Benami if it does not fall in any of these clauses. That is end of the matter, period. Excuse me. Sorry, can I have water, please? Thank you. Now, fiduciary capacity. Now, we'll discuss Section 88 of Indian Trust Act has not been repealed. Others have been repealed, which talks about fiduciary capacity benefit. So therefore, the concept of fiduciary capacity is still recognized under the law, and so is recognized with the judgment of Honorable Supreme Court in the case of P.V. Sankara Krupp versus Lilavati, 6 SCC 68. 6 SCC, 6 Supreme Court cases 68, 1994. Yes, property. Benami property means any property which is the subject matter of Benami transaction and also includes the proceeds from such property. So meaning thereby, अगर उसकी आपने प्रॉपर्टी बेच भी दी और उसकी प्रोसीड्स आपके पास आई हैं तो उसको भी रोपिन किया जा सकता है। मीनिंग thereby, आपके कर्म आपके साथ साथ चलते जाएंगे। तो देखिए, प्रोसीड्स भी बीच में रोपिन होंगी। Property. Now kindly see how widest and wildest definition is given. If you want to see the property, kindly see, don't need any dictionary. The widest and wildest definition is given here. Assets of any kind. Kindly read this definition with me. Immovable, tangible or intangible, corporeal or incorporeal, and includes any right or interest or legal documents or instruments evidencing title to or interest in the property, and where the property is capable of conversion into some other form than the property in the converted form, and also includes the proceeds from the property. So friends, कन्वर्टेड फॉर्म की जो प्रॉपर्टी होगी वो भी इंक्लूड हो जाएगी, यानी कि फिजिकल कन्वर्जन, नॉट मॉनेटरी कन्वर्जन। मॉनेटरी कन्वर्जन तो प्रोसीड्स नहीं है। फिजिकल कन्वर्जन मींस लाइक ज्वेलरी का आप मींस गोल्ड बिस्किट्स की ज्वेलरी बना लीजिए, डिबेंचर्स के शेयर्स कन्वर्ट हो गए, रॉ मटेरियल का फिनिश गुड्स बन गया, तो फिजिकल कन्वर्जन भी इंक्लूड होगा बेनामीदार। इट मींस ए पर्सन और ए फिक्टिशियस पर्सन एज द केस में बी इन हुज नेम द बेनामी प्रॉपर्टी इज ट्रांसफर्ड और हेल्ड and includes a person who lends his name. तो देखिए दोनों बातें आ गई कि एक कोई fictitious person होगा। अब मैं ये नहीं समझ पा रहा fictitious person से क्या मतलब है। Anyways, let us leave it at that stage. In whose name the Benami property is transferred to or held, and the person includes a person who lends his name. यानी कि अगर किसी ने ये कहा कि साहब मैंने तो खाली नाम दिया था साहब, वो तो मेरे जो वो हैं माई बाप, वो साहब वो यूज कर रहे थे सारा मेरा अकाउंट, मैंने तो खाली नाम लेंड किया था। The moment a person admits name lending, he is admitted benamidar. Nothing more is required to be proved. And the treatment of benamidar is very special, which we'll learn very shortly. So, the moment a person admits to be lending the name, he is straight away benamidar. Beneficial owner. It means a person whether his identity is known or not, for whose benefit the benami property is held by benamidar. Now, kindly see how strangely the law has been drafted. On the one side, Benamidar means a person or a fictitious person. On the other side, Benami beneficial owner, whether his identity is known or not. So I was also wondering कि भाई ये कैसे ऐसा क्यों लॉ लेकर आए हैं कि on the one hand a person or a fictitious person, fictitious be, or identity known or not. फिर अगेन टू बी ऑन द लाइटर साइड, मुझे लॉजिक इसका वही मिला कि उसमें क्या कहा था उन्होंने कि देखिए शरीर तो नश्वर है, आता है जाता है, द बॉडी इज पेरिशेबल, इट कम्स, it goes, takes birth and dies. So the soul is immortal. So you recognize the soul, find it out and prosecute him. आत्मा को ढूंढ, उसको पकड़ और उसी को प्रोसिक्यूट कर दे. So after reading this definition, let me come to the initiating officer. Here starts our association with Benami law more intimately, because this is an officer from the income tax department. And those who do income tax practice get to meet this officer quite often. It means an assistant commissioner or deputy commissioner. So in दो rank के officers को designate किया initiating officer को, और इसका काम क्या है इनका? He is the law enforcement officer, meaning thereby enforcement का काम इनका है. He initiates the proceedings. He personifies his name by initiating the proceedings. So meaning thereby he sets the ball rolling. Approving authority. It means an additional commissioner or a joint commissioner as defined in clause 1C28 on Income Tax Act. What is his role? The role is akin to the role as is performed under section 151 of Income Tax Act to approve the reasons recorded by the assessing officer for issuance of notice under section 148 read with section 147, etc. Adjudicating authority. Now, this authority's function is to adjudicate upon the orders passed by the initiating officer. It is to be appointed under section 7. No authority appointed under section 7. Therefore, adjudicating authority has been appointed under section 71, which is the authority discharging the function of PMLA, to whom this function of passing the adjudication upon the orders passed under the Benami law by the initiating officer has also been done. In simple words, the adjudicating authority of Benami law and PML is common as on date, located in New Delhi, having pan-India jurisdiction. And I got to know that adjudicating authority, even during the lockdown, has been functioning because of non-increasing the limitation by the honorable government. Though Benami law's time limit was extended, by PMLA time limit was not extended. Therefore, they had to function and pass certain orders. Then section 71 I have read. Then appellate tribunal. Now, after the orders are passed by the adjudicating authority, then the matter reaches before the appellate tribunal. Again, the pan-India jurisdiction of the appellate tribunal is in Delhi. Sole bench is located in Delhi. So it is to be appointed under section 30, but not established. Therefore, for the time being, the appellate tribunal established under SAFEMA has been given the function of PMLA as well as function of Benami law. So therefore, appellate tribunal is common of SAFEMA, COFEPOSA, NDPS, FEMA, PMLA, and Benami law. These 6-7 things, this one tribunal is discharging the function. NDPS means that narcotic drugs and all that. And this regularly hearing takes place, like court-like hearing we have over there. And before the lockdown began, matters were being argued on regular basis by us. Administrator means an income tax officer as defined in section 225. Meaning thereby he will acquire the property. After the acquisition of the property, he will hold the property, confiscate the property, hold it, operate it, run it, manage it, sell it, auction it as per the directions of the government. Then procedure. Then briefly I must share with you how it functions, how the whole scheme of the act functions, how the enforcement is done basically. In fact, as I said, the role of the enforcement has been given to the initiating officer. So initiating officer gets the information on pull mode and push mode basis from various other agencies and officers of the state government and central government. And then he has been given powers under section 19 to section 23 to carry out further inquiries. And if on the basis of materials so gathered, if he's of the opinion that so-and-so transaction or so-and-so property is Benami, then he can record reasons to issue notice under section 24(1) to the Benamidar and beneficial owner. And simultaneously, he can also make provisional attachment of the property by passing an order under section 24(3), which is popularly known as provisional attachment order, PAO in short we call it. And PAO like a bolt from the blue for any SSC, from any noticee, not the SSC, any noticee here, because under income tax proceedings, the attachment is done maybe at the fag end of the proceedings, or maybe not even in the lifetime, maybe at the fag end of the lifetime, or even of the lifetime of an SSC, usually after quite a long period, I mean to say. But here the proceedings begin with the attachment. So first brush or first feeling which comes to a notice is कि साहब ये जो प्रॉपर्टी है ना, ये प्रॉपर्टी तो सरकार की हो गई। अब आगे की बात करते हैं कि क्या प्रोसिक्यूशन एटसेट्रा और क्या पेनल्टी एटसेट्रा होनी चाहिए। So that is what this makes this law quite stinging, quite harsh, etc., etc. So after the issuance of notice under section 24(1) and 24(3), the IO is given 90 days period. During this 90 days period, the IO asks for the information from the notices. The notices give their replies. He can record the statement. Notices give their statements or produce any other evidence in support. And during this 90 days period, the IO takes an opinion whether this is a Benami property or not. If it is not Benami, the PO shall be released and proceedings will come to an end. But if it is found to be Benami, then PAO shall be continued, and the matter will be referred thereafter to the adjudicating authority within 15 days therefrom, and thereafter the role of the income tax department comes to an end, then role of adjudicating authority begins. Friends, one thing more, quite often we think that it is similar to income tax law because the power to make enforcement is with the income tax department. But sir, believe me, there is nothing common between the income tax law and Benami law, except that the power of enforcement is with the except that the power of enforcement is with the income tax department. So except this fact, there is nothing which can be said to be common. So since there is nothing which can be said to be common, so therefore it is because of the fact that the fabric on which the income tax law has been woven and on which the Benami law has been woven are totally different. And one such fundamental difference in the fabric is of the burden of proof. The concept of burden of proof is totally different under Benami law and under Income Tax Act. So burden of proof under income tax law is primarily on the SSC when he makes any claim. But under Benami law, this was a question which was bothering us initially. But when we argued this matter before the appellate tribunal, this was first appeal of the country, which I argued before the appellate tribunal in the name of Pamela Bhardwaj and Ramlik Singh Kochar versus initiating officer. In this case, Honorable Justice Manmohan Singh, through this judgment, has held that in view of the various judgments of Supreme Court rendered in the context of civil law, maybe Ammal Mangathai and P. Leelavati rendered recently by Supreme Court, the burden to prove Benami is upon the person who is alleging to be Benami. So meaning thereby the IO is alleging the property to be Benami. So burden to prove will be upon the shoulders of the initiating officer. So since burden to prove is upon the initiating officer, therefore while representing the proceedings before the initiating officer, one should not represent them in such a manner that the burden of IO is adopted by him. So this basic precaution should be kept in mind. So leaving it at that stage, I will proceed little further. After that, the matter reaches before the adjudicating authority. Before the adjudicating authority, again, it is a court-like hearing. And since it is a court-like hearing, 2 members, division bench, would hear the matter. And again, a Benamidar beneficial owner or any other interested party can do the hearing, participate in the hearing, file the reply along with the supporting evidences. The initiating officer would put forth his case. Then within 1 year, the adjudicating authority has to decide the matter. In case it decides that it is not Benami property, it will release the provisional attachment order and pass order accordingly. But in case the Benami office, in case the adjudicating authority decides that it is Benami, then it will confirm the provisional attachment order and hold the property as Benami. Though the there is nothing specifically mentioned in the law, but the adjudging authority must also decide who is Benamidar and who is beneficial owner. Otherwise, in my considered opinion, it will not be a complete order. And this issue also I raised before the appellate tribunal, and the Honorable Appellate Tribunal decided, yes, even if it is not decided, not prescribed in the law, but the adjudicating authority must decide who is Benamidar, who is beneficial owner. Then, after that, the order is passed by the adjudicating authority. What will happen to the confiscation? Whether immediately thereafter confiscation will take place, possession will be taken. Friends, that is where this law is different from PMLA law and lesser harsh than PMLA, because under PMLA, the moment adjudicating authority passes an order, thereafter the Benami law officer comes into action. After passes an order, thereafter the ED comes into an action and start taking over the possession because of the some strange drafting of law which is misinterpreted. But under Benami law, the law is very clear that the moment order is passed by the adjudicating authority, confiscation cannot take place unless the appeal is decided by the appellate tribunal. And if appeal is not filed, then of course the confiscation proceedings may take place. But if the appeal is filed, then firstly there will be proceedings. There will be proceedings with regard to the appeal. Appeal order will be passed, and only thereafter confiscation, if required, will take place. So the appeal is filed before the appellate tribunal by any party. Again, as I said, the appellate tribunal is established in Delhi. Can you please make no noise? Then important things I will be sharing with you. Some very, very important things. Prohibition on retransfer. As per section 6 bracket 1, this is the answer to the question which many people are asking, that whether U-turn is allowed. So friends, kindly see. The Benamidar shall not retransfer the Benami property as held by him to the beneficial owner or any other person. And if it is done so, such transaction shall be deemed to be null and void. So friends, in case Benami transaction has been done, the law has not given any channel of its compounding of the offense or reversing or correcting it. Rather, other thing has been mentioned, and the other thing is that it will not be retransferred. And even if it is retransferred, it will be null and void, meaning thereby the Benami transaction will remain as it is. So this is very, very harsh position which the legislature has taken. I do not know why. Subject to ifs and buts, subject to some payment of penalty, this thing should have been allowed and could have been allowed. I do not know for what reasons this has not been allowed. Now, section 57 is very important. Any transfer made after the issuance of notice under section 24 shall be ignored, notwithstanding the provisions of Transfer of Property Act 1882. So meaning thereby, in case on any particular transaction, 24(1) was already issued on any seller, on any person. So 24(1) issued. And from that person, if you have made purchase, then that purchase is null and void. That property is kuda. It's a piece of paper for you because of clear provision of section 57. Friends, the provisions of section 60 and 67 of PBPT Act are very, very, I would say, strict. And both the provisions, if read together, they say that number one, the provisions of PBPT Act are in addition to the provisions of any other act. And number two, in case there is any contradiction in the provisions of this act vis-a-vis any other act, the provisions of this act shall have overriding effect. So meaning thereby, if anything contrary is noticed, of no use, because the provisions of this act will prevail. So this is also again a very strange situation. There is no mechanism to know whether 24(1) has been issued. There is no short mechanism to do. Of course, we can make research at the office of the registrar, but it is not necessary that a person will come to knowledge about that. Then second thing, friends, again very important. Suppose when you purchase the property, 24(1) was not issued, and 24(1) is issued thereafter. Then what? So what will happen to that? Whether this transfer will be void, what will happen? Actually, friends, in that case, attachment is possible by the initiating officer subject to the provisions of section 24(3). But the requisite safeguards are not generally being taken by the I would say the officers nowadays, and therefore their actions are proving to be quite harsh. And there is a concept of provision of protection to the bona fide purchasers under section 26 of PPPT Act, and even that protection is not being neither being properly provided nor being properly availed by the people. Now, because the section 26 protection again is coupled with the two concepts, the two conditions, that A, there should be there should be payment of adequate consideration by the bona fide purchaser, and there will be no knowledge of the there being Benami transaction to the bona fide purchaser, to the said bona fide purchaser. So the fulfillment of two conditions are necessary. Now the question arose, whose burden is to prove that these conditions are not fulfilled? Because whether there was no knowledge is a negative concept. It cannot be proved negatively by the bona fide purchaser. And the bona fide purchaser can tell about the consideration, whether it is bona fide, it is absolute or not. Who will tell? So this issue also arose, which we argued before the Honorable Tribunal. And in two judgments, I got the relief. Very good judgments worth sharing. One in the name of Vargo Township, and other one subsequent judgment. It was from Pune. Notices for us. Company was from Pune in the name of Kavita Infrastructure, and the earlier one was from Jaipur. And both of them was decided by the appellate tribunal here at Delhi. And both the judgment, both are at the site of the appellate tribunal available, so it is in public domain. Anyone can read them very beautifully. They have given the concept of bona fide purchaser, and it was held that the burden is upon the initiating officer to prove that these conditions are not fulfilled. And without discharging this burden, the protection to the bona fide purchasers must be given. And then, friends, after confiscation, any transfer shall be void. Then no compensation payable by the government on the acquisition or confiscation of the Benami property. Then, friends, no claim shall lie against the central government for attachment or vacation of the Benami property. Then, friends, this prosecution part is very important, but I would be leaving this prosecution part because Amit Khemka ji will be taking up in detail the prosecution parts. So this prosecution section contains three areas: that who will be prosecuted, and what circumstances will be prosecuted, and how he will be prosecuted, and who will be prosecuted. So I will request Amit Khemka ji to also take up the third person, that is a person who abets or induces any person to enter into Benami transaction, because it is a great need for us to understand its concept and depth. And section 54, of course, will be taken up. Then another section 54A has been added, Amit Khemka ji, that is not in my slide. If you can, sir, take that also, because it talks about penalty for non-appearance before the initiating officer. Then what is the nature of these offenses? Kindly cover that also in your slides. And then standing operating procedures on implementation of PPPT Act issued by CPPT. In fact, 24 BPUs have been created all over the country. BPU means Benami Prohibition Unit. These have been carved out from the investigation wing, and comprising of these officers, additional commissioners, deputy commissioners, ITO, and other officers. Then functions of BPO is all functions under PPPT Act, and also criminal prosecution, also criminal functions, criminal prosecution related monitoring, and coordination functions under Black Money Act and Income Tax Act. This second function is very, very important, because now special courts have been designated. So prosecution work, related work also will be now coordinated from the BPU. In fact, this question was also arising, how the information is being gathered. So the guidance note has been issued by the Central Board of Direct Taxes that from these sources, the BPU should gather the requisite information, that is identification and examination of legal apparent owners and beneficial owner during the course of search, etc. Then whether the property is held, transferred for the immediate or future benefit, direct or indirect, of the person other than the person who has provided the consideration. Then examination of the source of the funds through which the property was acquired. Then whether a transaction or arrangement in respect of the property has been made in a fictitious name. Whether the apparent owner is not aware of or denies knowledge of such property. Such a situation may lead to classification of the property as Benami property. A property where the person providing the consideration is not traceable or is fictitious may also be classified as Benami property. Then, upon identification of property as Benami property, or in case where the investigation officer has prima facie reason to believe that property in question may be Benami property, the information after the approval of the controlling officer should be passed on to the initiating officer within a period of 60 days. The initiating officer thereafter may take necessary action under Section 24. So, from these pull mode and push mode streams, the IO is getting the information, and that is how. Now, the question arises how the benefit test will be complied with. In fact, we need not travel much for that, because direct judgment of Supreme Court throws some light, Jay Dayal Poddar versus Bibi Hajra, which was followed by in many judgments, including this judgment of Honorable Punjab and Haryana High Court in the case of Rajendra Prasad Malik, wherein they said that you have to see basic ingredients to judge whether who is the real owner, who is the beneficial owner. That is, for example, the first ingredient could be the source from which the purchase money came, the nature and possession of the property after the purchase, motive, if any, for giving the transaction a Benami color, the position of parties and the relationship, if any, between the claimant and the alleged Benamidar, the custody of the title deeds after the sale, the conduct of the parties concerned in dealing with the property after the sale. Then, friends, we can either take a question answer session or some basic about the interplay. This question is bothering to many people, if I am allowed to share this with you. So I will be sharing only one or two things here. In fact, there is going to be now strong interplay between various laws. Now, I will give you, before taking up this slide on interplay, I will share with you one practical situation which has arisen in one case. Now, what happened? One gentleman who owned big chunk of land sold around 100 acres of land, and it was agricultural land, and to get the benefit of deduction under Section 54B, it purchased another chunk of land and claimed deduction under Section 54B in its return. When the assessment proceedings were going on, it was asked by the assessing officer that why the deduction under Section 54B show cause was given. Why the deduction under Section 54B not denied? Because the land has not been purchased by the gentleman in his own name. Now, the accountant of the gentleman was quite bright. So he represented and he gave a very good detailed reply that, look, sir, there were social exigencies due to which the land had to be purchased for family reasons in the name of the daughter-in-law of my boss. But otherwise, my boss is the absolute owner, real owner. He is exercising full dominion and control over the asset. And kindly see, the entire agriculture income is being deposited in his bank account only. So kindly allow the deduction under Section 54B. Give me the benefit of the judgment of Honorable Rajasthan High Court. Though one judgment is against me, but this judgment is in my favor. So give me the beneficial judgment in view of Supreme Court judgment of 88 ITR 92 in the name of vegetable products. So usually the conduct of the or action of the AO is to deny the benefit and adopt the adversarial judgment and ignore the beneficial judgment. But in this case, the assessing officer allowed the benefit under Section 54B to bring the matter to an end. But the matter was not brought to an end because the notices came, this time 3 notices came from the Benami Prohibition Unit, that is initiating officer. And the first notice was issued to the daughter-in-law that you are the Benamidar of this land. Another to the gentleman that you are proud beneficial owner of this land. And the property is hereby attached. Now let us talk about its prosecution, which Amit ji will be explaining how it can be. And third notice came to the accountant because he was again and again saying, yes, I advised them to do so. So his third notice came to him also, and how it can come, Amit ji will explain in detail. So friends, this is a classic case where a strong interplay you can observe that by trying to save him from income tax, he pushed him into the deep wall of Benami law. Another example I can quote, 2 brothers purchased one house comprising of ground floor and first floor. And the intention was to live together jointly and so the deal was done. But when the time of sale registration of deed came, the younger brother was traveling abroad, so he requested his elder brother, ki, brother, I am sending you my share of rupees 5 crore into your bank account. You can please make full payment and get the registration done, lest this deal slips out of our hands, and we may lose earnest money also. So elder brother agreed, and he purchased the property in his name only, get the registration done in his name only, and both the brothers eventually started living together. During the course of assessment proceedings of the younger brother, the assessing officer asked him to prove some claim in the name of house tax or house rebate, etc., then or some interest. So then the sale deed was presented, and then AO noticed that sale deed was not in the name of that assessee, that is younger brother. So he gave show cause notice through BPO that why it should not be treated as Benami property, because you are the beneficial owner, your elder brother is the Benamidar, and this first floor is Benami property. So that is how there is a strong interplay between the income tax and interplay, and unknowingly Benami transactions are done. But as far as attraction of Benami law is concerned, there is no scope of any good intention or bad intention. If a transaction is Benami, it is Benami. Similarly, there is going to be strong interplay in section 68 and Benami transactions. The share capital which may be added may be prone to Benami law also, which we can discuss in detail in our subsequent sessions, which I'm going to take maybe tomorrow or day after tomorrow. Nitesh Bhai would be telling more about it. So friends, as far as other laws are concerned, there is a strong interplay with money laundering law, because whenever money laundering, and probably tomorrow I am taking session on money laundering, I'll be discussing in detail about the money laundering, what is money laundering, and how there is an interplay between money laundering and Benami law and other laws. And now there is going to be interplay between the Companies Act and SEBI regulations and Benami law also, because if a person is found to be acting through some other persons to acquire shareholding, then Benami transactions can also be invoked. So friends, I think that is where I have explained most of the cases with the help of practical scenario also. Now, I think our question answer session can also take around 15-20 minutes and more, and we have another speaker also. So I think it will be better if we take another question answer session round. And before beginning, coming to the question answer session, I will request I will give one request that as I have been often saying, that the time has come when we must realign ourselves. In fact, in nutshell, taking clue from that fundamental legislation of 5,500 years old, I will say that हम जैसा अंदर से सोचते हैं, हमें वैसा ही बाहर से सोचना चाहिए. Whatever I am thinking inside, I should look to be thinking from outside. Whatever I am inside, I should be out from outside also that way. Whatever I think is mine, I should think that only to be mine, and I will tell others that it is mine only. Whatever is not mine, I should never think it is mine, and never should tell others that it is mine. So, in other words, I should live a real life, and I should get rid of Benami life. So wherever there is a concept of duality which will pitch in, there will be problem. So non-duality, as was guided by him, will only save us from this problem. So long as there is no distinction between the ownership, so long as there is one owner who is legal owner as well as who is beneficial owner, the concept of Benami law cannot pitch in. So it's a message to retransform our life in a much better way. So with this, friends, I will request the organizers to take us to the question answer sessions and devote sufficient time thereon before I hand over the session to Amit Khemka sir in this regard. Sir, so can I stop share now and we can come to question answer session? Yes, sir. Yes, sir. Nitish bhai, can you come? Who will be coordinating?
Yeah, this is CA Mahesh Kumar Bajoria from Raniganj.
Yes, Mahesh ji. Ji.
Yeah, the question is from Rajendra Khandelwal.
Ji.
Dairy seized in the survey scrutiny proceeding.
Yeah. Mahesh ji is there. Sumitra is there.
68.
They will be asking. They will
Made in
be
68.
asking the questions
SSC
which has
accept the
been raised
entire
by the
amount
members.
noted in diary, the money in his name. If the cash SSC deposited, whether the cash been benami hit. Again, I am repeating the question.
Yes, I understood the question. Very good question asked,
Okay.
Bhai. Look, as I told you, the best fundamental concept which I should remember with regard to Benami law is that there has to be duality. That there has to be distinction between the legal owner and the real owner, the legal owner and the real owner. So, if the person is accepting his own money, so only income tax come into play, not other acts, not Benami law. Benami law will come into play if the transaction is done in Benami name. Suppose he says that it is somebody else cash which he was holding. Only then in clause D or in clause A, he can be robbed in. But if he accepts it to be his money only, I think then the provisions of Benami law should not be hit. Yes. Next question, please. Can I see the questions myself so that I can pick up the most appropriate questions? Any list of questions somewhere?
Hello.
Nitesh ji.
Hello.
Nitesh ji.
Yes.
Nitesh ji, list of questions, please.
Hello.
Ram Sevak ji is asking this question. This question is coming, then again it is hiding. Yes. So, as far as this section 53A is concerned, as I read, there's only exception number 5, which is intending to protract the transactions done under section 53A, whereby part performance has been done or whereby power attorney has been issued. So, 2-3 conditions are given there. If these 3 conditions are fulfilled, only then there will be protection from Benami law. 3 conditions are that the person who has issued the power attorney remains the original owner. Then secondly, stamp duty has been paid. And thirdly, sale deed, not sale deed, the contract to give power attorney that has been registered. So if these 3 conditions are fulfilled, then it can be saved from the rigors of Benami law, not otherwise. So you might be thinking that it is very difficult to fulfill these 3 conditions. Yes, these questions are in great danger of attraction of Benami law, friends. Yes, sir.
Hello.
Yes, sir.
Hello. May I put a question here? We received here. That is from Deepak Builders and Engineers India Private Limited. A purchased hotel in the name of B. A purchased a hotel, but for purchasing the hotel, B directly paid the amount. A is employer of B. But
A purchased hotel from B.
No, sir. A purchased hotel from someone else, and that for payment of that purchase, B who directly paid to the settlor, and A is employer of B. But they make an agreement of loan between them. A and B made an agreement. At such, in the house of the Mr. B, original land deed registration copy founded in house of B. A has no source of income. What will be the effect in that case?
Yes, sir. Look, though many things here will depend upon appreciation of facts, but I will give you broad guidelines how it works. As I said, when I was reading the part A, part B, part C, D, part A, B, C, and D of the clauses, I was saying that it is essential that whatever conditions are there, that should be fulfilled. So if we talk about part A, 2 conditions were mentioned. Yes. तो बाकी सब लोग बंद कर दें, अपना म्यूट कर दें और फिर बाद में जब जरूरत पड़े जब ऑन कर लें, माइक को म्यूट कर दें जब जरूरत पड़े जब ऑन कर लें. Yes. So let us talk about part A only. In part A, 2 conditions are required to be fulfilled. That is, beneficial interest is also to be fulfilled. So mere making of payment by B will not be sufficient. It is also essential that B is enjoying the property beneficially. So long as there is only a relationship of borrower and lender, he has only financed, then it cannot said to be Benami unless anything else is brought on record that the real owner is B, B is having control. Unless this is brought out, there is direct judgment of P. Lilavati of Supreme Court, which says that mere giving the finance will not make it Benami. For example, this judgment in the case of Pamela Bhardwaj or in the case of DHFL, which I argued before appellate tribunal, this P. Lilavati's judgment has been quoted and they said mere giving finance will not make it Benami. Supreme Court also says, now Honorable Justice Manmohan Singh and Honorable Shri G.C. Mishra ji has given in their judgment, this you can read the judgment which are available online on the site of the PMLA tribunal. Otherwise, I will send to AIRC and it can be circulated from there. Ji sir.
Okay.
Next,
One
please.
question has come from Amit Kumar Agarwal. Question is whether legal representative of beneficial owner is also liable for legal action if beneficial owner dies before initiation or during the proceedings under that. What is the effect?
Very good question, sir. You have asked, and that is why I was saying कि इसमें future time limit क्या है? अगर आपको ध्यान हो तो मैं लाइटर वे में कह रहा था कि ना इसमें भूत ना भविष्य कि somebody would say कि साहब आपने लाइफ टाइम में नहीं मेरे को छेड़ा, मेरे बच्चों को परेशान करोगे. वो मैं लाइटर साइड में तो कह रहा था, बट लॉ की पोजीशन कुछ इस तरह की है कि हो सकता है प्रोसिक्यूशन ना हो because the person has died, but the attachment can take place because if it is Benami, it is Benami, forever Benami. So even if it changes hands, so long as it remains Benami, it will be Benami, or its proceeds may take place. So very weird situation it has created. With regard to prosecution, I think I'm leaving the session open for Amit Khemkaji. He will be covering up what will happen to the prosecution proceedings and the such attachment can take place. Yes, sir. So, sir, can I have the list of questions? Can I see the list of questions? Whether this technology allows us?
Oh, sir, I have.
Sir, in the chat box, you can see the questions raised by the members, and they are picking these questions from there, sir.
So I cannot. Chat box is there, but I don't see any question over there.
Sir, one question, sir.
Yeah, please.
One question.
I'm not getting the chat box open. Yes. Can anyone help me? Ji.
Sir, one question came from Dinesh Agarwal. Any credit in the books of account as unsecured loan and such credit entries declared under Income Disclosure Scheme 2016, whether these transactions covered under Benami Act 2016.
If you remember, there was section 290 of Finance Act 2016, which specifically mentioned that in case you make payment of tax on transfer to retransfer of Benami transactions, then we will give you immunity from the provisions of PBPT Act. There was a specific section brought out to protect such, meaning thereby the purpose was that whosoever is having Benami transactions, we are giving 3 months shorter windows, and only though that window was with the purpose of realignment of transaction only, so that these transactions could be saved from the rigors of the Benami transactions and people can make corrections. So because of that protection under section 290, the prosecution provisions of Benami law will not be applicable thereupon, and it will not be treated as Benami.
Okay, sir. One question more from that is came from Ashok Ray. If any property is purchased jointly with married daughter and self, and given the purchase consideration by himself, and is shown in the books of accounts jointly, so is it Benami property? Benami transaction?
No, because jointly it is jointly and it is in the name of child. I think there will not be any problem. Not Benami.
Someone asked about.
Sir,
please continue. Sir, someone made question that regarding the little bit of more explanation, example regarding the fiduciary transaction. Fiduciary is the benefit of fiduciary capacity.
Fiduciary capacity.
Fiduciary capacity.
Yes, yes.
A little bit of example in any case. Was the example of fiduciary capacity.
Hello.
Example of fiduciary capacity. Can I read the questions?
Please, CA P.K. Jain, he has given the question. Please explain fiduciary capacity with some example?
I think for the trust purpose, trustee are in fiduciary capacity, I think.
No, fiduciary capacity example I gave. For example, a company purchases property in the name of director. Director holds the property on behalf of the company. It will be fiduciary capacity. Similarly, partnership, partner of the firm. Nominee who is holding share on behalf of holding company will be holding it in fiduciary capacity. Trustee holding it on behalf of trust will be holding it in fiduciary capacity. So fiduciary capacity, which is recognized under the law as fiduciary capacity. Ji, sir. Next.
Sir, you told that in case of property that may be movable or it may be immovable, any type of property that can be made as a Benami transaction. So one question has came from Shipra Jain. She asked, kindly throw light on banking transaction. How will be covered under Benami Act and how to bring them out?
No, banking transaction, sir, kindly throw light on the banking transaction. How will
I think she
I will explain. I will explain. Suppose the FD is done, say, or bank account is opened in the name of Mr. X, and Mr. X says, sir, this is not my account. If it is proved that he is maintaining this account on behalf of Mr. Y, and Mr. Y is a real owner. One example. Other example, say FD is kept in the name of Mr. X, and it is proved that X has nothing to do with the FD. The entire control is being exercised from Y. Then again, it will be Benami. Y will be beneficial owner, X will be Benamidar, and that FDR will be Benami property. G. Next.
Okay. Sir, Obisek Maheshwari, one question came from you. Initiating officer issue show cause notice only to Benamidar and not to the beneficial owner. Is there any issue?
As the law says that the notice may be issued to the beneficial owner if his identity is known. So if his identity is not known, then it is not necessary for initiating officer. It is not mandatory for the initiating officer to rope in the beneficial owner or to definitely bring on record the beneficial owner. But hold on, the situation is not that simple. What is privilege, what is given, the relaxation which has been given by the legislature to the initiating officer is not to identify the beneficial owner. But relaxation is not giving the permission even not to hold that the Benamidar is not holding the property for his own behalf, but is holding it on some other behalf. So meaning thereby it is mandatory for the initiating officer to give a finding that so and so person is not holding the property for himself. He is not the beneficial owner. He is only a namesake registered owner. So this finding is mandatory. Under these circumstances, he can add one other line, but at the moment I am not able to identify who is the other owner. But I am able to give this evidence. He has to give it this finding with the help of an evidence that this person is only a namesake owner. So that is how then he can do away with the issuing notice to beneficial owner. Otherwise, he has to mandatorily issue notice to the beneficial owner. He has to bring on record that the benefit test is being complied.
Hello.
Thank you, Abhishek.
आप एक बार आ जाइए ना फोटो में.
Hello.
जी.
One question came from Narendra Parikh.
तो आप इस पर लिस्ट में दे देंगे क्वेश्चन बोलने से पहले एक बार यहाँ दे दिया कीजिए. जैसे अभी अभिषेक जी का क्वेश्चन आपने दिया है, सामने आया हुआ है मेरे, ऐसे दूसरा क्वेश्चन भी दे दीजिए. वो पढ़ने से मुझे ज्यादा क्लियरिटी हो जाती है.
Can I ask you, sir?
Yes, please.
Okay. He made a question. If A purchased property in other name, other than exclusion, as you given the exclusion in the list, if A purchased property in the name of other than exclusion, but shown in his account, under fixed asset, in the balance sheet he has shown the fixed asset under fixed asset, whether it is called Benami?
Sorry, come again. I'm sorry, voice broke up in between. A purchased the property.
A purchased the property in other name.
Okay.
Other name, but without the exclusion that is given by you.
Okay. Okay.
But that property
was shown in the balance sheet. Shown in the balance sheet.
Yes, sir. Yes, sir.
Actually, this is very, 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 very important, friends, and everybody must listen very carefully. even despite maintaining the transparency of showing it in the balance sheet, you will not be able to save yourself from the rigor of Benami law. आप ये नहीं कह सकते कि सर मैं के नाम से प्रॉपर्टी रख रहा हूं लेकिन मैं ट्रांसपेरेंटली डिस्क्लोज कर रहा हूं अपने बैलेंस शीट में. नो, दिस परमिशन इज नॉट गिवन. If it is Benami, it is Benami. Even if you show in your balance sheet and admit it to be Benami, it is Benami. So therefore, even showing in the balance sheet would not save it from the rigors. Our Amit Khemka sir has joined. So any remaining questions can be...
One last question. That has come from Sanjeev Kadel.
Ji.
What about transaction in Delhi, which are by way of power of attorney and out of unaccounted transaction? Is it considered?
Actually, this is a very, very important issue, and so far no actions have been taken. But literally speaking, all such transactions are prone to action under the Benami law. And I hope Amit Khemka sir would also agree, and during the course of his discussion, he should also cover, I would request, this PO cases, because we have a detailed discussion in this regard. Yes, sir.
Okay. Okay, sure.
So, ji, sir.
I would request Devan Patro to kindly for vote of thanks to the learned speaker. Treasurer, yes.
Yeah, thank you very much. Thank you, Ashwini Taneja sir. It was great listening to you. You gave your time. You answered so many questions for us. And you during your deliberation on this Benami law, you have pointed out the importance of the law as a retrospective law, the court judgments in regards to that. And importantly, you have also made us aware, all chartered accountants, about prosecution, how important it is. And yes, Amit sir will be deliberating on that. Sir, we are very thankful on behalf of EIRC and all the members that you have taken out time from your busy schedule. You must be having many more meetings like this, and you have given us time. Thank you so very much, sir. Thank you so much.
So see you tomorrow in session on anti-money laundering law, wherein I would also try to cover, if any more questions are left, we will be taking up that time. And today I don't want to take up the precious time and the benefit which we are going to have from the discussion of Amit Khemka ji. Is a wonderful orator and speaker, and a very staunch lawyer. You would see his rich experience when he will be speaking on the aspects of prosecution. So thank you, Nitesh bhai. Thank you, all the organizers. Thank you, everyone. Sumitra Saab, everyone. Thank you very much. Thank you, audience, for the keen participation. Thank you.
I would request the learned speaker to kindly start, please. Amit ji, please.
Am I audible now?
Yes,
Yes, sir.
Yes, sir.
Okay. Respected More Saab, Sarkar ji, Bajoria ji, Patra ji, and the two other chairmen of NIRC and CIRC, Mr. Shashank Agarwal and Mr. Somani. It is absolutely a pleasure to be talking to such learned, such learned mass of people from almost 2/3, or you can say almost half of India at least. So it is my pleasure to be talking to you. And but what happens is that after you have such a lucid and eloquent speaker before you, and especially when you are in the afternoon, it is, of course, difficult to come up to that expectation. But the other benefit is that the other speaker has already set the tone. Friends, right now we are, the whole world, our own country, we are all going through a very, very difficult time. And it is heartening to see that people like Mr. More, Mr. Goyal, and all of you, all your team are utilizing this time in a very, very positive way, because this is the time when our positivity should not be lost. Our compassion should not be lost. We can only be compassionate when we are positive, and we can only be positive when we are doing certain positive things. Let me come now to the basic subject of the today. Friends, I have been speaking to the chartered accountants for very, very long time now. I used to speak on drafting. I used to speak on cross-examination. I used to speak on so many other subjects. But in last few years, I found that whenever I talk to chartered accountants about the prosecution part, most of them had the attitude that no, it is not concerned with us. And when we were handling our cases in prosecution courts, in the courts, in trial courts, we were facing a lot of problems without the help of the chartered accountant. And especially because the client in all the fiscal matters, in all the economic matters, does not come to us directly. He first goes to a chartered accountant who actually makes or breaks his case in the initial stage itself. And if a chartered accountant has not, I'll tell you that I went to Bombay, I went to Hyderabad, I went to Chennai, I went to so many other places, and wherever I have talked to the chartered accountants, I find that most of the chartered accountants and tax practitioners have not even read Chapter 22 of Income Tax Act, which is, Income Tax Act is your Bible. Income Tax Act is your, your whole life. In fact, a chartered accountant cannot imagine life without Income Tax Act. But there is one chapter which most chartered accountants have not read after having passed the course of the chartered accountant or after getting the degree. In practice, they do not even go through those provisions. So I thought it to take it on myself to at least, this course is called refresher course, to at least refresh the, the memories of the chartered accountants and the tax practitioners, to the extent that when they are preparing a case for any default, or in case of any default by a particular SSC, then in that case, they must have it on their mind as to what are the consequences so far as the criminal law or criminal part or prosecution part is concerned. The problem has become more complicated with the advent of newer and newer laws. After in 1991, this country adopted a new path of the economic reforms. So as reforms came, the human mind was such that it tried to find out the ways to make illegal or unlawful or uncalled for benefit out of those liberalized policies or reforms. But then, as a knee-jerk reaction, the governments kept on bringing out new and new law. First, they brought Prevention of Money Laundering Act. Then they brought Black Money Act. Then they brought a huge new company law, where very serious and severe prosecution provisions have been made. Then they came up with IBC. They are also huge, very strong prosecution provisions have been made. Then they came with the amendments in the existing Benami law, and there also the prosecution provisions have been made. Now, all these acts, in fact, there are a lot many I can go on, but all these laws have provisions which are of criminal nature, where the prosecution is provided for the normal breaches. And each one of these laws has an interplay with each other. If you see that, because they are all dealing with the economics and commerce and fiscal matters, so they all have the interplay with each other. And in these circumstances, it is all the more important for a chartered accountant to at least have a rough idea, a fair idea of as to what are these laws, what is the interplay between them. And whenever we are doing our job, we must have it on the back of our mind that these laws and the criminal repercussions are also there, and how one should also handle in case a criminal action is started, how that should be handled. And last but not the least, it is also very important that how the professionals must deal with the attitude of arm's length approach. I call it arm's length approach. We must not get into the problems of our clients or the SSC. Whatever they might be doing, we should never become a party to it. We should not be seen as parties to that. And especially now, when the repercussions can be very, very severe. In fact, we are seeing in prevention of PMLA cases, lots and lots of professionals, company secretaries, chartered accountants, they are made co-accused. So that also is a matter of worry, that we must have the approach of arm's length so that we at least do not become parties to whatever wrong a client or an SSC might have done. So friends, with this background in mind, I will, because I know that most of you do not have a basic idea of these laws. So I'll take you, it is not possible for me in this 1 hour time to take you through everything, but I will try to take you through some of the important provisions of which are prosecution provisions of these laws. So I'll let me now start sharing the screen. Can I now request everyone else to please mute their mics so that we don't hear any other noise? Friends, in Income Tax Act, it is chapter 22, which deals with the provisions for prosecution. And it is a very interesting, or if I may say strange law, where a person is actually penalized in the shape of penalty on the adjudication side, and then for the same offense or for the same wrong, there are provisions which make him culpable for to undergo certain punishments in the shape of imprisonment and fine. So penalty is there, then imprisonment is there, and the fine is also there. So this is a this makes it kind of a very tough and very, if I may say, to an extent a little draconian that one is being, but it seems that the legislature in its own wisdom has thought that it is necessary in order to implement the tax laws in a proper manner, that these provisions are required. So the chapter 22 starts with section 275A, which talks of anybody contravening any order made under section 132. So the 132, as you all know, that whenever any directions are given to maintain any status quo in respect of any property, or any other order is given then by an officer, then, and if it is not followed, then the punishment is for 2 years, and it could also be fine. Now, please see that in this particular section, there is no requirement of mens rea, as we normally understand that for criminal law, there has to be a mens rea. There has to be some intention, some fraudulent intention, there is nothing like that. The mere violation of the orders or mere violation of the not following the directions will attract the provisions of this section. Then failure to comply with the provisions of IIB and subset. So wherever the SSE or the person whose accounts or documents are sought to be inspected does not provide mere facilities to the officer. For example, he does not provide his password of the computer, or he does not provide proper facilities. It's a very wide word actually. Again, here there is no mens rea required. There is no intention required. And very, very strangely, now, very recently, the new guidelines have come in the last year from the board, and these two sections are no more even compoundable. Although it is questionable when I come to the compounding part, I will discuss that. But even these two sections, and then the third section is failure to comply with the provisions of, whoever fraudulently removes, conceals, transfers, or delivers to any person any property or interest therein, intending thereby to prevent that property or interest therein from being taken in execution of a certificate. So wherever the somebody wants to, there is a similar provision. In fact, even the Benami law prosecution part takes care of it. But this is also there in income tax. This has been there for quite some time. So all these three sections have even been made non-compoundable. Now you can see in this particular section 276 that the element of mens rea is there. Whoever fraudulently removes, and then the word intending is also there. So here the mental state is there, the mens rea is there, but in the other two sections, if you saw, there was nothing like mens rea also. Then the other important section is that 276A, but it deals with the liquidators' powers and liquidators' acts. If he fails to give notice, fails to set aside the amount as required in subsection 3, parts with any of the assets of the company or the property in his hands, then he is also liable to be prosecuted for that. Then comes the TDS and tax collected and tax deducted. So 276B, if a person fails to pay to the credit of the central government the tax deducted at source by him, or the tax payable by him, under 1150, 194B. So the punishment will be not less than 3 months, and it could extend up to 7 years. Then the same punishment is there for in respect of tax collected under 206C. So these two again don't have any element of mens rea. If you see, the mere violation is enough. The only saving grace now in respect of 276B and 276BB in the recent circular, in the recent guidelines which were announced in June 2019 by the CBDT in respect of compounding, etc., and in respect of how the prosecution must be launched. So the CBDT has said that in respect, if the offense under 276B and 276BB is up to an amount of rupees 25 lakhs, and the amount is actually, the delay is up to 60 days, then in that case, the prosecution shall not be launched. So this is the only saving grace in respect of these two sections, apart from, of course, 278AA provides in respect of only 276B that if a person can show the reasonable cause for the delay or non-payment, then in that case, one can, that might be a defense for this purpose. Because 278AA says that no person shall be punished for failure referred to in the said provision if he proves that there was a reasonable cause for such failure. But this particular defense is only a defense. It is not that it is a necessary for the prosecution. Prosecution just has to prove that there was a default, and that's enough for the prosecution. However, 278AA allows a defense to the accused under 276B if he can show that there was some reasonable cause for such failure. But unfortunately, in case of 276BB, even that defense is not available, and the mere fact and that the tax which was collected and was not paid to the credit of the central government is enough to punish that person with punishment which will not be less than 3 months and which could extend up to 7 years. So friends, you can see the severity of these provisions, and you as well as your clients have to be aware of the basic ideas about these defaults. Now the question arises whether delay in depositing TDS also attracts prosecution. You know, it is always a pleasure to be addressing a live gathering, but then you can but where you can actually interact and have questions and counter questions during your deliberation. However, in that case, one is never able to address such a huge gathering from all the three regions. Whether the question arises, friends, whether delay in depositing TDS also attracts prosecution. The answer is that yes, even for delay, the prosecution can be launched. However, as I told you, that in the month of June 2019, the CBDT has come with this relaxation that if the amount is up to 25 lakhs and if the delay is up to 60 days, then in that case, prosecution shall not be launched. Then friends, one of the most important sections of the income tax law, income tax prosecution law, is 276C. We get maximum number of prosecutions under this particular provision. If you see, if this particular section has two parts, that one is 276C1, which talks of if a person willfully attempts in any manner whatsoever to evade any tax, penalty, or interest. Now, so far as 276C2 is concerned, it talks of if a person willfully attempts in any manner whatsoever to evade the payment of any tax. Now, on the first look, both these subsections look similar, but they are not. While 276C1, for your benefit, I am again taking you to the slide. 276C1 deals with willful attempt to evade tax, while 276C2 deals with willful attempt to pay tax. So friends, while 276C1 deals with evasion of tax, while 276C2 deals with evasion of payment of tax. So while the 276C1 comes into picture, even without there being an assessment, if there is an evasion of tax, the tax, the 276C1 prosecution could be launched. However, 276C2 will only come into picture when there is an assessment. It could be self-assessment. It could be assessment by self-assessment also. If you have filed the self-assessment returns, but tax has not been paid, then in that case 276C2 shall be attracted. Or where the assessment has been made in any manner whatsoever, then and the liability, the tax, penalty, or interest have not been paid, then in that case also 276C2 shall be attracted. However, the 276C1 can be attracted even before the conclusion of the assessment proceedings. Now there has been a debate going on. There is an identical section as 276 in the new Black Money Act now, which apart from increasing the punishment part, because if you see in 276C1, the punishment was if the tax evaded is up to 2.5 lakhs, then 6 months, minimum 6 months, more than 2.5 lakhs, then it would be minimum punishment of 6 months and up to 7 years. And in case where it is obviously less than 2.5 lakhs, then in that case, minimum punishment of 3 months and up to 2 years and fine. So the punishment is very severe for, I will just come back to, and what is the meaning of evasion of tax? It has been clarified by way of explanation. Willful attempt to evade tax for the purpose of section shall include a case where any person has in his possession or control books or other documents containing false entry in the books of documents, omits or causes to be omitted any relevant entry, or causes any other circumstance which will have the effect of enabling such person to evade any tax, penalty, or interest. Now, we are all aware that talk of the town now is 271 AAD, which makes the mere false entry in the books or documents or omission in the omission, as attracting the penalty, and which is a very severe penalty which has been imposed. But here, so far as punishment is concerned, so far as the prosecution is concerned, it is only in case where these entries have been made in order to evade tax. 271 AAD is where you may not have done anything to evade the tax, still it attracts penalty. However, in 276 C1, the evasion of tax or any false entry in books or documents or omissions, they will only be punished when there is a willful attempt. So there is a mens rea in this particular thing. There's a willful attempt in making all these entries and with an intention to evade the tax. There's an identical provision in Black Money Act, as I was earlier telling you. And in this, the only difference is that in case it is in respect of a foreign asset, then in that case, the punishment will be increased. You saw earlier it was 3 months to 7 years. Now it will be 3 years to 10 years. I'm sorry. So friends, for evasion of tax under Black Money Act, the punishment is from 3 years, minimum punishment of 3 years, and up to 10 years. And then for willful evasion to pay tax, it is minimum punishment of 3 months and up to 3 years, while in the Income Tax Act, it is up to 2 years. So apart from changing the punishment, in Black Money Act, not even a single word has been changed in this section. So I really wonder that why couldn't an amendment have been brought in the Income Tax Act itself rather than having a separate provision in the Black Money Act. So even the explanation is the same. Now the question arises whether the assessing officer has to wait till the completion of assessment for initiating the prosecution under these sections. Now, the law on the subject was the prosecution can be proposed or initiated even before completion of the assessment proceedings so far as subsection 1 is concerned, that is the evasion of tax. However, in respect of subsection 2, it can only start after the assessment is completed and tax, penalty or interest has become due. But this was the law till September 2019, when the CBDT has come out with a new guideline, where the CBDT has said, if I could take you to these are the new guidelines which the CBDT has come up with. On 9/9/2019, and as I told you that CBDT in respect of 276B says that if the tax deducted is up to 25 lakhs and the deposit is less, delay is up to 60 days, then the prosecution shall not be launched. Now, in respect of 276C1, a very interesting direction has come, that is that the further prosecution under this section shall be launched only after the confirmation of the order imposing penalty by the ITAT. So you can see that all this law, that prosecution could be launched together with the penalty proceedings also. Now that is no meaning after these recent guidelines of CBDT that they have to wait in all penalty proceedings. They under 276C1, they have to wait. The department has to wait till the conclusion of the appeal before the ITAT. The other interesting thing has come is that cases where the amount sought to be evaded or is rupees 25 lakhs or below shall not be prosecuted for prosecution except with the administrative approval of a collegium or two. So that I will come to when I will deal with the provision of in relation to the compounding. Impression is there in the mind of many professionals that the Black Money Act only deals with the cases where the source of funds is not explainable. Now, if a person, it is believed that if a person has, say, any asset or a house or a property outside the country, and he is a resident today, and if he can explain that that property has been acquired with tax-paid money, legal money, then in that case, the provisions of Black Money Act will not be attracted. You may be right to the extent that it will not attract any tax incident. However, in Section 49 and 50 of Income Tax of the Black Money Act, mere non-disclosure of such assets is made punishable, and the punishment is also very, very severe. If you see punishment to failure to furnish return in relation to foreign income and asset, so the mere non-furnishing of return in respect of the income, whoever willfully fails to furnish in due time the return of income shall be punishable with rigorous imprisonment for a term which shall not be less than 6 months and which can be up to 6 months. What is the return? It has to be a resident other than not ordinary resident. It only applies to that person and held any asset, including financial interest in any entity located outside India as beneficial owner during the previous year, or was a beneficiary of such asset or had income from source outside India. So it is anyone who is filing the returns as a resident, who is not filing, he is a resident and not filing the return in respect of an asset held outside India where he has he is the beneficial owner or is a beneficiary of such asset. So it could be even if it is Benami, even if it is held in someone else's name and he is the beneficiary of it and he has not disclosed it, or he had some income outside, then he is supposed to disclose if it was in the previous year. Now these incomes, maybe he might have paid tax, they may be purely legal, there may be no tax liability. However, the mere non-disclosure or mere non-filing, the Section 49 deals with not filing of return in respect of these assets and income, and 50 deals with the where the return has been filed, however fails to furnish in such returns any information relating to the assets located outside or income from a source outside. So, friends, it is very important to understand that it is not merely that you are that the Black Money Act, so far as adjudication part is concerned, so far as tax incident is concerned, it may not be there. Still, it was necessary to disclose all that income, all that assets which a resident possesses outside India. Then coming back to Income Tax Act, failure to produce accounts and documents. If a person willfully fails to produce or cause to be produced on or before the date specified in any notice under 140, such accounts and documents as are referred to in the notice or willfully fails to comply with the direction shall be punishable up to 1 year and with fine. A very interesting case comes to my mind, and which I would like to share with all of you. What happened in one of the, today, nowadays, all the returns, all the replies are being filed by the chartered accountants, because they are all being filed electronically, they are all being filed online. So, the reply was filed to the notice, and in that notice, probably it could not get uploaded, or the mail bounced because of the default of somebody in the office. And later on, the mail was sent, but in that mail, the chartered accountant has given that reply in his own name, on his own letterhead. So the notice under 276D for default in not furnishing the document, he records a statement of the SSE. SSE says, I had given all the documents to my chartered accountant. And the notice comes to the chartered accountant under 276D. When I talk of working at arm's length, if you recollect, when we lawyers work, we will always file a wakalatnama first. Second, every document which we file, we will say, Mr. So-and-so, or the petitioner or the respondent, through Amit Khemka advocate. But that is not so in the case of chartered accountants. Chartered accountants are writing communications as if they are themselves the SSEs. I have seen letters and replies where the chartered accountant doesn't even say that my client has authorized me to say this, or I am saying this on behalf of my client. So, friends, we have been able to tackle this. However, the question is that we have to be much, much more careful in whatever pleadings we are doing. The last thing a lawyer like me would want to defend a chartered accountant in any criminal court, or any professional brother for that matter. False statement in verification. This is yet another provision which is very frequently utilized by the department in prosecution cases. Now, friends, which is this verification we are talking of? The section is talking of. If a person makes a statement in any verification under this act, or under any rule made thereunder, or delivers an account or statement which is false and which either he knows or believes to be false, or does not believe to be true, he shall be punishable. With, if it is up to 2.5 lakhs, 6 months, above 2.5 lakhs, 6 months minimum and up to 7 years. And in any other case, minimum 3 months and up to 3 years. Now, friends, the verification, this is which verification is it? It can be a verification in an affidavit, which you have furnished, and it could well be the verification of a return. So, this section, wherever there is a false statement has been made, whether in a return or in any other pleading, this section can be attracted. This brings to my recollection a case which we are doing, and that case, what has happened is that a search takes place. Can you just excuse me? A search takes place. The SSC surrenders some income of about 5 crores. Also, at the same time, he gives an FDR to the officers and says that whatever tax and interest is there, please deduct it out of my FDR, and authorizes them to recover it from that FDR. The tax and interest is recovered, and thereafter the notice under 153A comes. In response, the chartered accountant goes and on his own letterhead, he writes a communication to the assessing officer saying that consider my return under 139 as returns under 153A. Friends, the officer not only makes addition, but also and imposes penalty. But he also, because the return under 159, when treated as returns under 153A, you can understand that it did not contain the surrender which was made. And surrender was there in the statement of the SSC. The whole defense that the interest was already paid had fallen flat till the Supreme Court, that the tax and interest have been paid. Because they said that you were taking a chance that if you had Shamu. So you were taking a chance that if by mistake, if the returns under 139 had been accepted as returns under 153A, you would have claimed the refund of the tax and interest which you are alleging to have been paid. So the prosecution was launched under 277, where they said that you made a false verification, treating 139 return as a return under 153A. My chartered accountant brother was lucky that they did not make him an accused and an abettor in this offense. However, we are taking the plea that so far as the SSC is concerned, SSC never made any false verification. He never made a false 153A return because he never filed. So he never made any. But let us see what result comes out. but it is a very, very sensitive situation where one has to be very careful because the punishment you can see is very, very severe. Then punishment for false statement and verification. It is in the Black Money Act in the identical form. A similar provision is there in Black Money Act in identical form. 277A, falsification of books of accounts. Now this, if any person willfully and with the intent to enable any other person, hereinafter in this section, referred to a second, evade any tax or interest or penalty, makes or causes to be made any entry or statement, which the first person either knows to be false or does not believe to be true in any books of accounts or other documents. To be true or useful in any other proceedings against the first person or the second person under this act, the first person shall be punishable with rigorous imprisonment for a term so and so. So it is not only, you can't get away by saying that, oh, this was made by my accountant, I did not know about it, it was his mistake. So this provision has been made for that particular purpose. Of course, abatement of filing the false returns. If a person abets or induces in any manner the person to make and deliver an account or a statement or declaration relating to any income or any fringe benefit chargeable to tax, which is false and which either knows, then again the abettor is also liable to the same punishment. The identical provision is there in Black Money Act as well. Now, the prosecution to be at the instance of the principal chief commissioner or chief commissioner. Now, all the prosecutions can only be launched with the previous sanction of commissioner or commissioner appeals or the appropriate authority. There is an identical provision in Black Money Act as well. Now the question is, what has happened now in September 2019? CBDT has almost changed this legal position, which is the part of the Act, saying that in certain provisions, in respect of certain offenses, if the tax liability or the tax interest or penalty is up to 25 lakhs, in that case there would be a concept of collegium of 2 or 3 principal commissioners or CCITs, and only with their permission, only with their approval, the prosecution shall be launched. However, if it is more than 25 lakhs, then in that case, the provisions of 279(1) will continue. It is not understandable. The circular is absolutely not clear, at least in respect of many, many sections, as to what is the cause, what is the reason that this has to happen, except for 276(1)(c)(1), where it says that if it will not be launched in the normal course where the tax penalty is up to 25 lakhs, it will only be, prosecution will only be launched if it is more than 25 lakhs. And therefore, if it has to be launched in respect of offenses where the tax liability or penalty or interest is up to 25 lakhs, then in that case, it will have to go to the collegium of 2 or 3 principal commissioners or CCITs. However, it is not understood. There is a table made. That's why in other cases, the provision for the collegium has been made. What is the purpose? It is it's a very sketchy and creepy, if I use the word, circular. Then there is an identical provision in Black Money Act. Now the question arises whether a show cause notice is a must before initiation of the prosecution. Friends, the answer was long back given in 2003 by the Honorable Supreme Court that no show cause notice is required by law before grant of sanction. However, the department as a practice is invariably issuing show cause notices not only in income tax law for prosecutions under income tax law, but also under the Black Money Act. Friends, in my view, this is the stage wherever you foresee when the penalty proceedings start and the chartered accountants foresee that it could lead to prosecution, or it does have some ingredients of the prosecution, then in that case, I feel that even at the stage of preparing the reply of in the penalty proceedings, a prosecution lawyer who is ultimately going to handle the case should be involved. However, even if he has not been involved at that stage, this is the time when the team must be made. With all due respect to all my brethren, and you people are such galaxy of learned people, I have to say that either because of lack of knowledge or because of some casual approach, or because thinking that the prosecution is not our job, the replies which are normally drafted by the chartered accountants to the prosecution notices, they do not take into consideration the legal requirements or the defenses, or there is hardly any strategy which has been thought of before giving those replies. My request to all our friends is that this should be the last stage before which a prosecution lawyer must come in the picture. Number one. Number two, I also want to say that you should not treat it as if now the matter has gone to the ball has gone in the court of the prosecution lawyer, so I am not concerned. Let me tell you, this is a job which can only be conducted by a team of a good chartered accountant and a good prosecution lawyer. It is not possible for a prosecution lawyer also to handle the matter alone or independently, because it requires the fiscal part, the criminal law part, the prosecution part, and the devilish, if I may use the word, sometimes we have to be the devil's advocate. So the criminal lawyer will start by being a devil's advocate, while the chartered accountant may not be very suitable for that job. But that devil's advocate may not be good enough for when it comes to the serious fiscal and economic matters or the commercial matters. So please tell your client that, look, this matter has to be handled together by both of us, and you have to understand that you have to compensate both of us for our commercial, our professional acumen and indulgence. And now the question comes that there is a thought process. There is I believe that we should give a sketchy reply or we should give a, if I can use the word, goal-mole reply to the prosecution notices, and we should not disclose our defense in the prosecution notices. Otherwise, the concerned officer will become more aware, and he will plug those holes in when he will file the complaint before the court. Friends, the truth lies somewhere in between. You should be able to, if at all you have to hold back certain information, you should be able to examine as to whether by holding back that information, you are actually doing good to your client or not. Sometimes, because these notices are given before the sanction is granted. Now, one of the major defenses before the court is that the sanction was not proper. And the sanction by the officer, if I had given some reply where I have noted all the issues involved, or where I have to a large extent given my defense, and the sanctioning authority has not applied its mind to those issues which I have raised while granting the sanction, because sanctions are normally pre-drafted. They hardly even read the replies filed to the notices. Then in that case, I will be able to get the benefit during the trial. So the question still remains that you have to evaluate. You just can't follow any one of these approaches blindly. One has to think of whether I am going to hold back. What is it which I am going to hold back? Will it actually help me in the trial? Will it actually help me if I come out? But maybe you hold back something, and when you tell it to the court later on, the court said you were given this opportunity of notice, you never give it. So even that might go against you. Even the court's sympathy might vanish from you. So all these things one has to think at this stage. This is the last stage to prepare the strategy for any prosecution, any defense, because I will come a little later to the fact that there is a lot of defense onus in these laws on the accused or the defendant. Now, this is what is compounding. Compounding itself is a topic on which we can devote at least 2 hours. But I have told you that certain new circulars have come in 14th June 2019 and 9/9/19, where lots and lots of changes have been made in the compounding law. While this particular section says that any offense under this chapter may, either before or after the institution of the proceedings, be compounded by the principal chief commissioner or chief commissioner or so and so. But if you read now these three circulars rather, which have come, drastic changes have been made to this provision of compounding under the Income Tax Act. One of them is that 3 of the offenses under the law have been made non-compoundable, while the Act, you can see, says that any offense under this chapter is compoundable. So it is a question, I put it a question to myself, that can CBDT, by way of its directions, make certain offenses non-compoundable? Now that is one thing which they have done. Second thing which they have done is that they have created 2 categories. One category is category A, other category is category B. Now there also they say that in one category offenses can be repeatedly compounded, but in this category they can only be compounded twice. So all these things. Another thing which has come up is that but if you can see the language, that either before or after the institution of the proceedings. So it was a normal practice with us that we would wait for application for compounding till almost the conclusion of the trial, when we will see that, okay, no, we are not getting any relief from the court, or when we were not able to take out anything during the cross-examination, we will file an application for compounding with the department. But now that this circular of 14th June 2019 says that an application for compounding can only be filed within 12 months from the last date when the complaint was filed in the special court. Now, just imagine a case where the complaint was filed, however, the notice was not received by the accused for next 12 months for XYZ reason, whether the courts were closed because of corona, or the dates were given automatically, or the judge was on leave. There could be 1,000, or the postal problem was there, but it was not received. So he will receive. The limitation starts on the date of the department's filing of the complaint in the special court. One could have understood that if it was the date when I received the summons, or when when the charge is framed against me, but no, it is from the date of the filing of the complaint, only 12 months. And after having made that provision, the department realized in September 2019 that, there could be cases which were filed maybe in June or July 2018. So their limitation expired in July 2019. So then they came out in the month of September that the date for filing of all the application as a last one-time last opportunity, it was extended up to 31st December, and later on it was extended up to 31st January. However, now if a complaint was filed, say in July 2019, in January 2019, then no compounding application can today be filed. However, fortunately, there is a provision where up to 12 months, that is up to the 24th month, it can be condoned for the reasons given. However, the compounding fee shall be 1.25 times of the normal compounding fee, and also some interest will be payable on that. Then, friends, this is section 279 is continuing subsection 3. This talks of a statement given under the impression that a person was given an assurance or belief that the penalty imposable would be reduced or waived. So the section says that any such a statement, is totally belief is unfounded, and any statement given will not be ignored on the ground that was given in the belief that the penalty imposable would be reduced or waived. Now, I have already discussed this relation between assessment and penalty proceedings. However, let me just quickly go through it. Whether the prosecution can be initiated before conclusion of the penalty proceedings, I have already given the answer. It could be in respect of 276 C1. However, now in respect of 276 C1, under the new guidelines, the department has to wait for the decision of the ITAT. However, these are two independent proceedings. The two proceedings can run simultaneously. Existence of one mode of recovery cannot act a bar for initiation of prosecution proceedings. If the penalty proceedings fail, can the prosecution continue? The answer has been given in the case of Radheshyam Kejriwal versus State of West Bengal. If basically if the prosecution, if the penalty proceedings fail on technical grounds, then in that case the prosecution may not fail. However, if it is on merits, then the prosecution will have to be dropped. Now, please appreciate that it is normally a practice with the chartered accountants dealing with the adjudication proceedings that they think that even if we are able to get the penalty, dropped or set aside on technical grounds, it is good. We have got the relief to the client. But please, for God's sake, keep the fact in mind that even if you get it dropped on the technical grounds, then also if it has not, the decision is not on merits, the prosecution may still be launched, and and if you have a case on merits, please fight it, please contest it on merits, try to get a judgment on merits in the penalty proceedings so that the prosecution, the SSC is saved from the prosecution as well. Can somebody tell me, because it's already 2 o'clock, can somebody tell me, should I go on or what should I do? Whether any of the...
Yeah, 5 minutes, 7 minutes, and we can wrap up, then we can take the questions, please.
Okay. So, I'm just skipping this part on the money laundering because Ashwini ji will probably take it tomorrow. However, I'm coming to the burden of proof. Now, friends, the time-tested principle of criminal law, which we were taught, and this Magna Carta judgment of Sharad Bridgen Sarda versus State of Maharashtra came in 1984, the same year when I joined the profession, rather in the same month in which I joined the profession, which said that the prosecution must stand or fall on its own legs, and it cannot derive any strength from the weakness of the defense. This is trite law, and no decision has taken a contrary view. But this kind of goes for a toss when it comes to the prosecutions under the PMLA or or even in the Income Tax Act. There is a provision here under 276(8)(e), presumption as to culpable mental state. You must have seen the words willfully, fraudulently, intentionally are there in many of the sections. There are sections where there is no mental state required, but wherever a mental state is required, the burden is on the accused to prove that he did not have a mental state. So this is a very onerous task on the part of the defense, and the preparation for that has to be made even at the time of penalty, drafting a reply in the penalty proceedings. From there itself, all the documents and material has to be preserved and collected, which can show that there was no such mental state, there was no intention, knowledge, or motive on the part of the person against whom the allegations have been made. The similar provision is there in Black Money Act, Section 54. Then coming to PMLA, in Prevention of Money Laundering Act, there is now a provision that there can be a presumption that proceeds of crime were involved in money laundering. So in all these three acts, there are provisions which say so. But does that mean that it is the whole burden is on the accused only? So fortunately, in a recent judgment of Supreme Court in Mohanlal versus State of Punjab, which has been given on the under the NDPS, Narcotics, Drugs and Psychotropic Substances Act, which has an identical provision in the act. So the court has said that, but that cannot be understood to mean that the moment an allegation is made and the FIR recites compliance with the statutory procedures leading to the recovery, the burden of proof from the very inception of the prosecution shifts on the accused without the prosecution having to establish or prove anything. So it is a saving grace that the prosecution has to prove the prima facie case, then only the burden will shift on the. However, as I said, that the documents and evidences to discharge this burden have to be collected right from the very beginning, and it has to be seen that they are not lost in the way. Then there is a very stringent provision in the Income Tax Act which says the proof and entries in the records of documents can be proved only by producing a copy of the entries that made entries of the documents and entries in the records of the income tax authorities. Now, this particular provision only finds a similar provision in the Black Money Act, and now a similar provision has been inserted in the form of Section 54B in Benami Act also. So otherwise it was never a practice in the law to have such a provision, but unfortunately it is there, which goes very much against the basic principles of Evidence Act as contained in Section 64 of Evidence Act, which says that the documents can only be proved by way of primary evidence, that is the original documents. Now, I'll just take a few more minutes for the Benami Prohibition of Benami Transactions Act because Ashwini ji had left it. So I'll just take you through the prosecution provisions under the Benami Act, PBPT Act. Prohibition of Section 3, this was the original section in the 1988 Act, which said that whoever enters into any Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years, or with fine, or with both. Now, if you read this used to be earlier the subsection 3, now it is subsection 2, and it says that whoever enters into Benami transaction. So while attachment could take place of a property held, as Ashwini ji explained to you, but the prosecution can be launched only for the incidence of for this purpose is entering into a Benami transaction. So the date on which the Benami transactions was entered into will be the relevant date for that purpose. Now, the punishment under the old act was up to 3 years, or with fine, or with both. Now, Section 468 of CRPC provides for limitations. Now, wherever the punishment is up to 3 years, then the limitation period for that is also 3 years. It is only for offences where the punishment provided is 3 years or more than 3 years that no limitation period is prescribed. So, this particular subsection applies to any Benami transaction which took place prior to 1/11/2016. Because if you see subsection 3 now, whoever enters into any Benami transaction on or after the date of commencement of Benami transaction, Amendment Act 2016, the date is 1/11/2016, shall notwithstanding anything contained in subsection 2 be punishable in accordance with the provisions contained in Chapter 7. I will take you to Chapter 7. However, it clarifies that subsection 2 applies only to those transactions which took place before 1/11/2016. And as I told you that the limitation for that was 3 years. So any offense which was committed under the old before 1/11/2016, the limitation for that expired as on 1/11/2019. So today, by using section 3(2), no prosecution can be launched. In my opinion, this is what is my opinion, and there may be some other opinion also. Now, coming to the cases where the Benami transaction was entered into post 1/11/2016, what is the position? Now, Section 53 of PBPT Act deals with Benami transactions entered into after 1/11/2016. Where any person enters into a Benami transaction in order to defeat the provisions of any law, or to avoid payment of statutory dues, or to avoid payment to creditors, the beneficial owner. So not all Benami transactions can be subject matters of prosecution. The first thing is that prosecution will only be launched for the act of entering into a Benami transaction, that is the incidence of the prosecution. However, there are 3 conditions only in which the prosecution can be launched. Number 1, where such a Benami transaction was entered into in order to defeat the provisions of any law. 2, to avoid payment of statutory dues, or to avoid payment to creditors. So as I showed you in Income Tax Act also, there was a provision that where anything was done to avoid statutory dues, it was punishable. Here also, if the Benami transaction, if you have done it, if you have removed the property and in the shape of a Benami transaction, in order to defeat the payment of statutory dues or to defeat the payment to creditors, then one is liable for prosecution under this provision. Then also, if it is in order to defeat the provisions of any law, there are almost every act, every state of this country has Land Reforms Act, where certain castes and communities have been specified from whom the property cannot be purchased. Now, it is a regular practice that people of the same caste are found out, the property is taken in their name and utilized by someone else later on. So that is in order to defeat the provisions of any law. If a person purchases a property in the name of his mother or wife or sister in order to defeat the stamp duty, because the stamp duty in case of women is lesser. So if it is for that purpose, then also it will be a subject matter of prosecution. Now, who can be prosecuted is, of course, the beneficial owner, of course, the Benamidar, but any other person who abets or induces any person to enter into a Benami transaction shall also be punishable. And you can see that there is a minimum punishment of 1 year prescribed, and the maximum punishment is up to 7 years. The fine can also extend to 25% of the fair market value of the property. Then the other section which talks of which also attracts prosecution is where the information is not furnished or knowingly gives false information shall also be punishable with rigorous imprisonment, which shall not be less than 6 months and which may be up to 5 years, and which may also the fine, which is 10% of the fair market value of the property. Then 54A has also come in, where not responding to the notices given by the IO can attract a penalty of 25,000 for every incidence. Again, this no prosecution under this law shall also be launched without the previous sanction of the board. Board in this case will be the CBDT. I will. Should I go on for another 6 minutes, or should I take questions now?
Sir, carry on. Please carry on.
Yeah.
Please carry on.
Yeah. All prosecutions under the PMLA, PBPT, as well as under the Income Tax Act commence with a complaint before a respective special court. All these laws provide for special courts. All these laws provide that the prosecution can only be launched by way of a complaint filed under Section 190 of CRPC. Now, we all know that the prosecutions, whichever the cognizable offenses are there, the police files a charge sheet or the challan, whatever or in fact, the technical word under CRPC is final report. But none of these prosecutions under these acts can be launched without a complaint. There is no system of filing a final report or challan under these laws. The provisions of Criminal Procedure Code are applicable in all these acts. These are the relevant sections. In normal course, when a complaint is filed under, it is brought before the magistrate or the special court under Section 200, he is supposed to record the statement of the complainant. However, since in these cases, the complainants are the public servants, they can be given exemption from the recording of a statement on oath by the magistrate in the initial stages. That does not mean that their statement shall not be recorded. Ultimately, during the trial, their statement shall be recorded. The opportunity of cross-examination will also be granted to the accused, and then only their statement, the complaint will be decided. Now, the law, which is CRPC, says that no summons or warrant shall be issued on a complaint if the list of prosecution witnesses is not filed. So this is one of the things which should be there with the complaint. Every summon or warrant must be accompanied by a copy of such complaint. Now, it is your duty, it is the duty of the court to, whenever the summon or warrants are issued on the basis of the complaints filed, that a copy of the complaint should be accompanied. Now, whenever a notice comes, the client normally gives ring to the chartered accountant and says, "Sir, we have received one more notice from the department of the court." So please tell him, because he may not be able to check whether the complaint is there or not, along with it, whether proper documents or annexures of that are there or not. Whenever he is receiving the summons, he should write that how many pages or how many number of pages he has received along with it, or if he has not received any copy of the complaint or any document, he must also write that I am only receiving the summons without any complaint or any other annexures or documents. It is, when a summon is received, the summon under the CRPC, which is issued, is a very deceptive document. It does not say that when the accused will appear on the very first day before the court, and even if the offense is bailable, then also the magistrate will ask him for furnishing a jamanti, the security, so which the magistrate is empowered under Section 88. So it has been quite a practice. We have seen it in our experience that so many clients reach the court. They says it is a summon. We have gone. So there, the judge tells him, "Oh, I have to send you to Tihar because you are not furnishing the security or surety bond." And so he has to be there with a surety. There has to be an estimation as to how much normally in such cases, how much security has to be given. So all documents in support have to be ready for that. So in fact, we people say taking a bail, so bail, kind of a bail will be given, even in the bailable offenses. Now, 205 of CRPC says that magistrate has the power to dispense with the personal appearance of the accused. However, the law is that accused has to be present on each and every date of hearing. It is only in exceptional cases for reasons reasons like illness or old age, something like that, the exemptions are granted, which can be granted. Now, another thing is that this stage is a very important stage. When in the initial stages itself, we have to decide whether we have to challenge the summoning order, whether the case is made out against us or not, whether the complaint discloses the prima facie case or not, whether the sanction is proper or not, whether it was after due application of mind, whether the material sufficient was there or not, whether it was impacted by extraneous considerations of material, whether the findings of the sanctioning authority are perverse. So all these materials have to be decided at that stage, because there is a limitation. If you have to challenge the sanctioning order in revision, for example, then summoning order, then there is a limitation of 30 days for that. So a quick decision has to be taken at this stage. It can't be that the matter cannot be dragged because up to bail ho gayi, now we can go and rest, we will come on the next date. So that should not be the approach. Some proactive action has to be taken at this stage. We also have to see whether grounds exist for summoning or challenging the summoning order under 395(7) or under section 482 to High Court, or wait for the stage of framing of the charge or notice to raise the plea. Thank you so much for the patient hearing. I have not taken the PMLA part. Maybe Ashwini ji will tomorrow take it. Thank you so much, and I invite any questions.
Sir, can you take the PMLA part in 10 minutes or so? Because there are so many persons who are asking for the this part in the chat room. So if you please can, if you have sufficient time.
I have.
Yes.
Friends, the issue normally arises is as to what is money laundering. Now, money laundering, this is the definition. This is the definition on which the courts, the lawyers, and everybody have been at crossroads, if I may say so, and have been applying their minds as to what does these 7 lines mean. And I will like to read them with all of you. Whosoever directly or indirectly attempts to indulge, or knowingly assists, or knowingly is a party, or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use. So, whoever is directly or indirectly attempts to indulge, or knowingly indulges, or is a party, or is actually involved in the process or activity connected with the proceeds of crime. Now, what are proceeds of crime? I'll just take you first to that. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value. I'm not getting into that. Now, proceeds of crime are not the proceeds of any crime. Proceeds of crime are not the proceeds of all crimes. In US, for example, in America, the proceeds of crime of any offense are covered, the allegation of money laundering can be made. But in the case of our law, there is a schedule prescribed in the Prevention of Money Laundering Act, and the proceeds of crime have to be derived or obtained directly or indirectly from, as a result of criminal activity out of one of those scheduled offenses. So there are scheduled offenses given in that list, in that schedule, and if as a result of the criminal activity by one of those crimes, if the money has been derived, if the proceeds have been derived, and they are, if I can come back to section 3, they are directly or indirectly used, possessed, acquired, or used, then it is money laundering. Now we were reading, now comes the main issue. The word end, the conjunctive end, and projecting or claiming it as untainted property shall be guilty of offense of money laundering. So friends, it is but natural that when we are talking of money laundering, laundering as the word says, washing, cleaning. So unless there is an attempt of converting the ill-gotten money into good money, into from bad money to good money, till then the offense cannot be there. And as the definition it existed, it said and projecting or claiming it. So one of the acts before the word and later on projecting or claiming it as untainted property shall be guilty of offense of money laundering. So the position was that the interpretation of this section was that if, first of all, there should be a crime, which is one of the scheduled crimes given in the act, and then out of that, as a result of that offense, there must be some proceeds of crime which must have been generated. And those proceeds of crime should have been concealed, possessed, acquired, or you are a party to the generation of that, or you have used it, or in any way directly or indirectly connected with it, knowingly, and projecting or claiming it as untainted property shall be guilty of offense of money laundering. This was our understanding. This is also the understanding of the Gujarat High Court in the case of Zafar Mohammad Hasan Patta versus Deputy Director and others, Gujarat High Court. So there they have said that only if both the two prerequisites are satisfied, that is, firstly, directly or indirectly attempt to indulge, knowingly either assists or is a party or is actually involved in such activity, and if he projects or claims it to be untainted property. So this is what was the judgment, very clear judgment of Gujarat High Court in the case of Zafar Mohammad Hasan Patta. However, now after this judgment came, the government of India has recently come out with an amendment. And by way of that amendment, this explanation has been added. The explanation says, for removal of doubts, it is clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following. Now you will see concealment, possession, acquisition, use. After use, they have used the word or projecting as tainted money property or claiming. So where the end has been converted into or. One could ask that what was the necessity to give this explanation? They could have easily said that converted this and into or. They could have amended the section. But the problem would have arisen that any penal provision can have prospective implementation only. It can have prospective effect only. Then all the prosecutions started. Then all the properties attached till now by the department or the ED would have fallen flat. So what they have done very intelligently, they have attached an explanation and said that we never meant end by this word end. According to us, this end was always or, and we meant or only. So this is the situation today, that even if a property has not been claimed to be untainted money, or even if the offense of money laundering has, the so-called laundering has not taken place, then also the offense could be made out. Be it this explanation, because it is very recent, it has just come few months ago, so it is yet to be tested on the touchstone of the constitutionality and and in any court of law. Now, friends, one of the questions in the scheduled offences, there is absolutely nothing, none of the offences which I talked about, income tax acts, are there. So the question which is normally asked to me is that is there any relationship between the offences under PMLA and offences under Income Tax Act? Now, on the face of it, prima facie, it looks like that Income Tax Act, because it is not there in the scheduled offences, there is no relationship between the two. Because any of the offences listed in Chapter 22 of Income Tax Act do not form part of the schedule under the PMLA. Now, I will show you that it is not entirely so. For example, 51 of Black Money Act, as I read to you, the evasion of tax on so far as the foreign assets and foreign income is concerned, of Black Money Act is a part of the scheduled offense. 51 of Black Money Act is one of the scheduled offenses. Then any fraudulent act attracts section 417 and 420 of IPC, or even 447 of Companies Act, which are also scheduled offenses. I will give you an example of one of the cases which we are doing. There, a fraud took place, a siphoning of funds took place in a private bank by the its directors. Now, those directors, after siphoning of the funds, took the help of a chartered accountant who used to run the business of giving accommodation entries, and that chartered accountant, through his 9 companies, gave accommodation, and the property was purchased with the help of that. Now, SFIO is investigating under 447 of Companies Act that the fraudulent transactions have taken place, and that money has been, because these people, the chartered accountant and party, have assisted in utilization of such fraudulent money, the money which has been fraudulently obtained from there. So they are also co-accused in the SFIO case. The chartered accountant he is now also being, because an offense, the ED is also investigating. So because 447 is part of the scheduled offense, so the simple act of giving the entries, the accommodation entries, has attracted SFIO, the Companies Act violations. It has attracted the ED. It will of course attract the income tax prosecutions, and it will attract Benami prosecution under the Benami law also, because the chartered accountant has utilized 9 of his Benami companies, where all his drivers and employees were made directors, the people of no worth. So all these acts have been, that is the point which I wanted to make out, that they are all interconnected with each other. Then coming to next point, any false forged document which may attract section 467, 471, 472. Now let me just take you to the one more slide. What is forgery? Now, whoever makes any false document or false electronic record or part of a document or electronic record with the intent to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person to part with the property, or to enter into any express or implied contract, or with the intent to commit fraud, or that fraud may be committed. So whenever the document, there is a false document or false entry, then that is forgery. So it is, forgery is nothing else but making a false entry or false document or false record is forgery. And 471, which says that whoever fraudulently or dishonestly uses as genuine a document or electronic record which he knows or he has reason to believe to be forged or document, shall be punished with. Now 471 is a part of the schedule of PMLA. Now if I may take you back to one of the sections of income tax only, that is 276C1. This was the explanation of 276C1, which says willful attempt to evade tax is making false entry in the books or documents. So along with 276C1, there can be an allegation of section 471 of IPC, that is forgery, because whatever is the definition given of the false document or false entry in 276C1 explanation, same definition is there of the forgery, which is a scheduled offense. So friends, we cannot say that there is no difference between the income, just because income tax prosecution sections are not there as scheduled offense, there cannot be the provisions of Money Laundering Act cannot be or may not be attracted. So this is one thing. And second, I was going through the burden of proof. I read the section of burden of proof. I had just skipped section 24 of PMLA, which says that if any proceeds relating to proceeds of crime under this act, in the case of a person charged with the offense of money laundering under section 3, the authority or court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. Now friends, in my respectful opinion, what has to be proven is by the department and what was to be proven by the accused. The ED has to prove that there was a scheduled offense 1, that scheduled offense generated proceeds of crime 2, and the subject matter of the prosecution is those very proceeds of crime. Then only the presumption under section 24A can come in, that it can be presumed that those proceeds of crime are involved in money laundering, which according to me has become redundant if we were to read the explanation which I read of section 3, which said that the word or is already gone. So there is no question of any laundering as such now. It is the mere possession or concealment or acquisition or use or any one of these acts constitutes the offense of money laundering. So it is not that that you were to possess and then also to project it as the untainted money or claim it to be untainted money. That thing is gone. So there is no element of money laundering now. So section 24 is kind of redundant if we were to read this particular explanation as being constitutionally valid. I can go on, but I think I have taken more than 35 more minutes of my allotted time. Thank you so much for being so patient. I would have loved to address a live gathering, which would have been really, really fantastic. I would have got the chance to interact with all of you. Bore Saab, Sarkar Saab, if you have any questions, please.
Sir, there are so many questions. I would request Soumitra Sarkarji, convener Midnapur chapter, to kindly coordinate this question and answer session.
Yes.
Thank you, sir. Thank you, Amit Khemka ji, for your very attractive and nice presentation. So very good deliberation and in details you have given to us. And I think our members and the students have benefited. So many questions have come from the persons who have attended in respect of PMLA, in respect of companies' income tax, and in respect of prevention of Money Laundering Act. So, out of these questions, I just picking it up a few questions because time is.
Please start.
So, first question is regarding money laundering. Whose burden to prove? Whose burden to prove with respect to proceeds of crime? It's money in case of money laundering, in case of both directly or indirectly. Burden of proof.
Yeah. So I have just now said that the burden of proof will be, number one, that there was a scheduled offense which took place is on the ED. The burden to prove that that scheduled offense generated proceeds of crime will be on the ED. The burden to prove that those very proceeds of crime are the subject matter of the prosecution is on the ED. The only onus which section 24 shifts on the accused was that that he was to prove that he never claimed it to be untainted money. He never laundered it. So that was the only thing. So it is a fractured onus to prove. The first three things have to be proven by the department, by the ED, and the last thing has to be proven by the accused.
Okay, sir. Thank you. And we are coming in the question of PBPT. One question came from Mr. Mehta. Vehicles shown in books of accounts in the partnership firm. That is in the books of the partnership firm. But RTO got the registration in the name of one partner. Is it Benami transaction?
No, it will, if all the documents to that effect have been, are there, because it will be actually questionable that can it be, but partner acts on behalf of the firm. A property can be there in the name of the partner so far as the firm is concerned. That is, I think, in the exceptions.
Sir, one question came from Olav Jain. He asked, one company purchased branch office outside India, and necessary documents and the authorized bank where from the transaction has been done duly accounted for in the books of accounts of the head office. Is it required to file additionally in Black Money Act also?
No, when you are filing the returns, in those returns, now the form of the return has changed since 2015.
Okay.
So in those returns, even if everything is accounted for, then also any asset held outside which has which can be called financial asset, or any income from outside India has to be reported in the returns. It has to be part of the returns, otherwise that is an offense in itself.
Okay, sir. One question came from Rajesh Agarwala. He asked that property purchased in the name of elder brother, 5 crore amount is 5 crore. And he shown in his books of accounts 2.5 crore he invested to purchase the property. And he also shown that he gave a loan to his elder brother, unsecured loan, paid to his elder brother. So by this way, total 5 crore has been arranged in his books of accounts. What is the issue on that matter?
What is the issue? What is the question?
Sir?
What is the question?
Sir, whether it is Benami transaction, 2.5 crore.
No, if it is accounted for, if it is shown that there is no, and Benami transaction will only be if it is for his own benefit. If he has given a loan to anybody, which is a normal loan, this can't be just giving the money or just giving the loan is not Benami transaction.
Okay, sir. So more or less same questions has been asked by two persons. One is Dr. Asha Jain and one is Talb Draxi. The question is whether for same offense we'll have to go under imprisonment separately under different act like Black Money Act, PMLA, IT, etc.
Yeah, that is the position of law. I have given the example that one chartered accountant is being prosecuted, being hauled up under SFIO, by ED, by income tax authorities, and also by the income tax authority, by the Benami cell. You know, so that is very much there. This is the new India. This is the new India of the finance, where one act can have repercussions under many acts.
Okay, sir. Shurojit Dotto asked a question: what would be the consequence where accounts are yet to be audited at the date of produce under section 276D?
Accounts are yet to be audited under 276B. No, how can you say that it is an attempt to evade tax? Unless the returns have been filed, unless you have made some declaration, unless return has been filed, how can you say that it's an attempt to evade tax? It will be the same situation. Can any penalty proceedings be initiated? No penalty proceedings can be initiated at this stage.
Okay, sir. Malladi Muralidhar, he asked a question: if property purchased in the name of son's wife in case of Benami Transactions Act, whether it reflects in that field or not?
The daughter-in-law.
Yes, sir. Son's
Yeah.
wife, that is daughter-in-law. Yes, sir.
Yeah, it is. It is a Benami transaction.
Benami transaction. One M. Gupta and Company, the question has been arrived that if I purchase property in the name of my wife, it does not come under purview of PBP.
Yes.
Whether in such case prosecution can be made?
No, how can it be? Because it is in the exception. If it is in the name of the spouse, then it is in one of the exceptions.
Okay, sir. Thank you. Thank you, sir.
Thank you so much. Thank you very much.
We have Treasurer EIRC CA Devayan Patra. I will request him for the formal vote of thanks.
Thank you once again. Mr. Amit Khemka, Advocate Amit Khemka, sir. You have been very patient. You have been giving the deliberation very humbly for the last 2 hours. You have gone beyond the time that has been given to you. Many members were requesting to hear about the PMLA also, the prosecutions, and you have been kind enough to also deliberate on that. We are really happy that you have given us so much of time. There were more than 1,000 members, and this has been a very wonderful and successful program. It would not have been one if you would not have been there and given this deliberation for last 2 hours. And at the end, you have also answered so many questions. I thank you so very much. I thank the chairman EIRC. I thank CA Soumitra Sarkar, very senior professional from Malda, and all the participants who have been throughout the day with us. Thank you so very much. We have more programs. This is a 4-day refresher course. So I believe that you all will be joining on the next 3 days. Chairman, sir, if you would like to add anything at the end, I thank everyone once again.
So friends, tomorrow we are having 2 eminent speakers, and the topics are very none other than tax guru Dr. C.A. Giri Sahuja ji will take us Vivad Se Vishwas scheme, then the Finance Act Amendment Act, and we also have Ashwini Taneja ji who will be taking Anti-Money Laundering Act. So I would request everybody to kindly come tomorrow mornings also, join us tomorrow morning also, and request everybody to kindly join all the 4 days. And also, if you think that we should have charged, you have gained anything, I would request everybody that if you can donate something in the ICI COVID-19 Relief Fund, because we have to show to the PM that as a ICI we are together, and we are together with the PM in this crucial time. So request everybody to kindly pay some, maybe 1,000, at least 1,000 to this PM Relief Fund. And with this, thank you everyone. Thank you everyone. Thank you.
Thank you so much.